All right, Mr. Chair, we are live on YouTube. So whenever you'd like to start with your opening remarks. Thank you.
Okay, thank you. Again, once more, apologies. We're trying to get this both virtual and in person at the same time. It's also our first session of the new, our first meeting of the new session, so everyone has new laptops, and they don't seem to quite want to talk to each other. So apologies again. Good morning, everyone. In accordance with Section 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for permissions for provisions of the zoning bylaw that applies to I'll start over again. The Committee of Adjustment considers applications for variances for the provisions of the zoning bylaw that applies to property, permissions to extend or alter lawful non-conforming uses, and consents to sever property to create new lots. Our land acknowledgement. We acknowledge the land we are meeting on is a traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Just going to get into the hearing procedures now. The Committee of Adjustment hearings are now conducted in a hybrid in-person and virtual format, hence our complications this morning. Some applicants and participants may make their submissions in person. Thank you for all of you who have come in person today. Nice to see a big crowd again. Others will be participating virtually by electronic means through WebEx, an online digital platform. The meetings are also streamed on the Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch it on YouTube. Those who want to participate virtually and have registered in advance will be connecting with their computer, tablet, smartphone, or telephone and have the option of participating via video or audio only. All virtual participants will automatically be muted on entry. When your item is called, you will be unmuted by the moderator, one person at a time. We ask that you also mute your devices until you are called to speak. Those participating by video appearance will be temporarily upgraded to panelist when your item is being held. During this time, your camera will be enabled. You will only be visible during your 5-minute allotted speaking time. At all other times, your video will be disabled and you will be reinstated as an attendee. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Those participating through WebEx are not allowed to use share screen or any other panelist controls during video appearances. The host will remove you from the panelist role if you fail to respect this instruction. Receiving a copy of the decision of the committee. People attending in person today who want to receive a copy of the decision of the committee on an application must fill out a decision request card, and those participating virtually need to submit a written request for a decision by email. Please ensure that you include your name, address, and email address because the Committee of Adjustment and the Toronto Local Appeal Body will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee, you may be able to appeal the decision to the Toronto Local Appeal Body or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies as defined in the Planning Act are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. I will now go through the hearing procedure. We will call each item in the order listed in the agenda. When making your submissions, Where an application is uncontested, the agent or applicant may proceed with their presentation if desired. When the committee does not require a presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions and/or take the matter into committee for decision. Each speaker, including the applicant agent, will be given a maximum of 5 minutes to address the committee. I will comment when you are reaching your 5-minute point. Any presentations or materials you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept materials at the hearing today. When addressing the committee, please clearly state your name and address. Please remember to confine your remarks to the matters outlined in the application. The applicant or agent will proceed first and will make an application to the committee on the application. Please note that the committee may not entertain revisions to the proposals at the hearing today. The committee may decide to defer the application if substantially revised to ensure the revised application is accurate and that all those entitled to notice of the application are informed of the changes. Then individuals either in support or opposition to the application will be invited to speak. Generally, we first call on speakers in the hearing room and then those participating through WebEx. Committee members may ask questions of each speaker after they have finished their presentation. When all speakers are finished, the applicant agent has the opportunity to rebut only those issues that were raised by the speakers. This will mark the end of the discussion. The application will then be taken into committee for a decision. Just like to introduce myself. I'm Stan Komorik. I will be chairing the meeting today. To my left are panel members Donald Taylor and Dominic Belli. To my right is panel member Sophia Ruddick. Off screen, but we're working on it to get you connected. Hopefully by the time we get to the items. Okay, confirmation of minutes from the previous meeting.
Mr. Chair, I'll move approval of the minutes of the last meeting.
Seconder? I'll second, given that Dominic was not here and Sophia is still occupied. All in favor? Okay, minutes are adopted. Do we have any declarations of interest or conflicts of interest for panel members or staff for any of the items this morning? Okay, none noted. Madam Secretary Treasurer, do we have any closed files to be closed?
None today, Mr. Chair.
And do we have any requests for deferrals?
Not that I'm aware of.
Okay, thank you. Okay, as soon as we're connected, we'll start with the top of the agenda. But just before that, I wanted to raise an item that may need to be deferred. It's item 14, and I believe Mr. Vieira is on the line as a speaker for that item. Can we address that now?
Absolutely, Mr. Chair. We can speak with Mr. Vieira. Mr. Chair, Marco is unmuted. Marco, go ahead.
Good morning, Mr. Chair, members of the committee. Marco Vieira as the agent for my client.
Good morning, Mr. Vieira. Sorry to surprise you perhaps, but wanted to raise an issue with you and see how you feel about the possibility of a deferral. There's a neighbor who is in opposition who claims that there is some property boundary issues which are not our purview. However, it does speak to the fact that you do not have an up-to-date survey submitted as part of your materials. The survey you submitted shows a shed, not the existing structure which you are proposing to build on. And we're just thinking for clarity purposes that may be an issue. Would like to have your comment. Would like to have your opinion on deferring so that you can provide a full proper application. I think staff should have actually brought that to your attention on submission.
So, yeah, a bit of a surprise here, but through you, Mr. Chair, the survey was prepared back in 2017 when we applied for a building permit to build what it is there now as the existing garage that we're looking to build on top of. The revised proposal through our discussions with planning, we've actually eliminated the setback variances because the second floor was pushed entirely away from the footprint of the existing garage. I am aware of the letters from the neighbor, but there is some history going back between the neighbor and my client
Mr.
with
Chair,
regards to dispute.
Right now, Mr. Vieira, we're not getting into
We're
the
not getting
merits.
into the merits of the,
I know.
of the item. Really, the issue for me is that you're applying for, you know, your application really isn't complete because you don't, I mean, you have a site plan which references a survey, but that survey is not
Correct.
not part of the application package. I don't see it here unless we've
No,
missed
you're
something.
correct, Mr. Chair, and an up-to-date survey is an application requirement, so the applicant should have provided that when they submitted the application.
So the intent to defer is for us to obtain a new up-to-date survey. Even though this survey is only 6 years old and our proposal doesn't impact the existing garage, I'm assuming?
Your proposal is on top of the existing garage. The existing garage is not shown on your survey, and an up-to-date survey showing all buildings and structures as of today's date is required when you apply.
Just, okay, I guess I don't have much of a choice here in order to get the deferral and get a new survey, but I just wish it would have been let known before, because then we could have tried to get it done prior to the hearing.
Again, apologies, staff should have pointed that out to you on application, but then, you know, you're also an agent that's been coming to committee on a regular basis, and you should be aware of what is required.
Yeah, I'm aware, and I know that there's also discussions between, you know, neighbors and the two different surveys of how they obtain different information that conflict each other. So that's fine. We will obtain a new survey in order to, I guess, rectify the location of the fence along the back property line.
Okay, my concern isn't the fence, it's the garage, but anyway. Members, do we have a motion? You're okay with the deferral then, Mr. Vieira?
Through you, Mr. Chair, I am.
Okay, thank you.
Mr. Chair, there is a person present in the chambers that wants to speak to this file.
Oh, right, okay. Sorry.
Showing the fourth page of your attendee list.
Is the person here for 22 Acorn? Yeah, if you want to come up.
Oh, sorry, come up to the microphone, please. So what we're addressing right now is just whether we're going to defer the item as opposed to,
Okay.
so we're not going to discuss the merits of the item. It's just to get your opinion on getting a deferral.
I actually don't want to defer this.
Could we just get your name and address
Okay,
first?
my name is Eileen Zahler. I am the owner of 23 Poplar Avenue, which is directly behind the property that we're discussing. He's putting in a proposal for his garage, which is not in the survey you just said.
That's right, and that's what we're trying to clarify that.
Right,
So that
originally it was a metal shed,
okay,
very small metal shed. In 2017, the person who bought the property, Mr. Almeida.
okay, we don't really need the history at this point. I mean,
Okay,
the point of doing the deferral is so that we have full information to make a proper
Okay,
decision.
in 2017, I had my property resurveyed because Mr. Almeida removed several trees illegally from his property.
Okay,
This is
again-
how- I understand this, but this is the story that he's encroached on my property now since 2017. he has made a fence 2 feet into my property that was encroaching. My problem is, now that he's getting this approval for this garage, which was not a garage originally, it was a shed, metal, like a tool
It
shed.
doesn't really matter what it was.
Okay, so his fence is now 2 feet on my property. I submitted a survey of my property with my PDF. Okay, I'm a little nervous because this has been going on since
Okay,
2017.
but I would imagine it would be in your interest to have this deferred because he's not
No,
getting
it's
his
not,
approval.
because I've been deferring this since 2017. I started legal proceedings with him
Okay,
in
but would you not
2017.
want to get the situation clarified by?
Absolutely, that's
So the
why
best
I'm
way to
here.
get it clarified is that we have an up-to-date survey, is it not?
Okay, fine. Then we will defer it to another time while he submits his proper survey. So what survey did he submit?
It doesn't, it doesn't
this-
matter.
is
It's
this
not
the
the current
survey-
survey, that's the point.
Is this the survey he submitted to the
We
committee?
can show it on the screen. It's also from 2017.
Right, and the 2017, the boundary line, like the setback for this garage that he's saying that, is there, is wrong.
Well, that's why we want to defer this to get a proper survey so we
Okay,
can
why
make a
didn't he s-
decision as to whether it is wrong or not.
Okay, this neighbor is above the law.
Okay,
First of all, he removed my trees illegally. That's
Okay,
part
sorry.
of common knowledge.
That's not what we're here to discuss
Okay,
right now.
you're concerned, I'm concerned about the setback of this garage that's on my,
And we'll get that clarified with a proper survey.
okay, so he didn't submit the proper survey?
Not in our opinion.
Okay, that doesn't surprise me with this neighbor.
Okay, but then,
Okay, so how does that work? He's deferring it again? I have to come back here and state my case again?
if
Or
you
is someone
wish,
going to come out and measure the setback for this garage?
that's what the surveyor is going to do.
Right. Well, I had the survey done,
Okay,
and the
ma'am,
survey...
we're going in a circle now, so,
Okay, I understand that, but I submitted my paperwork to the committee showing that his fence is 2 feet on my property. And being a property owner, that concerns me that he didn't have any right to take my trees off my property.
okay, look,
He
I'm
put a
gonna have to,
fence 2 feet onto my property.
thank you for your input.
Okay, I guess I'm getting nowhere because,
Well, you are getting somewhere
Okay.
because we're going to get this situation clarified, and this is the only way to get it clarified.
okay, perfect.
Thank you.
Okay, so you're gonna defer this case to, am I gonna get another letter?
Yes, you will get another notice.
Okay, so I can't get this resolved today. He's deferring it because that's what he does.
No, we're deferring it. He didn't want to defer it.
Oh, he wanted it to go
He
through.
wanted to go through today. We
Okay.
are suggesting because it's not a full application, we're going to defer it.
Okay, perfect. Okay, so I will be.
It's not his choice.
Okay, perfect.
Thank you.
Okay, so I will get paperwork.
You will get a new notice.
Because I want to get this resolved.
Absolutely.
Okay,
Sorry.
thank you. That all? Okay, so you will contact me when you get the proper papers from him? Okay. Notified the first time. Okay, thank you very much. Thank you for listening to me. I really appreciate it, but this has been going and very expensive for me.
No,
Dealing with a
the
neighbor
main
like this.
reason we flag this is because it's unclear. And this is,
Right.
and in my view, and I don't know you, I don't know your
No,
applicant, I can't judge who's right and who's wrong without having the proper evidence
Right.
and information before me.
But right off the bat, he's saying that he submitted, the garage is still, the garage,
Okay,
it was
that's
never,
why it's being deferred.
it was never an existing garage, right from the get-go. It was
Well,
a
either
shed.
there's a building permit for it there or there isn't,
Oh,
but
yeah,
that's
there's
not, but that's not what we're getting into today.
But the building was approved because it's there.
Okay,
Okay.
thank you.
Garage is there. So I don't understand, what he's doing now. The garage is built already.
Well, that's a whole nother issue.
Right, but is the setback proper according
That's
to the
why we're
boundary line?
asking for a survey.
Okay, perfect. Okay.
They can't record or do anything with what you're saying right now.
Okay, thank you. I've taken enough of your time. Thank you. Bye-bye.
Members, we need a motion.
Mr. Chair, I'll move for deferral to enable the preparation of a new survey to clarify what's being proposed here and where it sits on the legal property.
I'll second.
All in favor? Okay, the item is deferred. Okay, let's try the top of the agenda. Now I'm having a problem with my computer. It's okay. Welcome to the first session, everyone. I got it. Okay, thank you. So item number 1 is 49 Church Street, and this is an application to construct a second-story garden suite above an existing garage in the rear yard. Sounds familiar? There are a total of 5 variances being requested. Planning is requesting 2 conditions of approval should the committee wish to approve. And I believe that's all that we have. And I have Charles Bunker as a speaker. Welcome.
Thank you. Welcome. My name is Charles Bunker. I'm the owner, or the applicant and the architect. The owner wishes to put a second suite on top of the existing garage. The variances are related to the location of the existing garage, and I don't believe the variances will have any effect on the neighbors. The owner has developed this property, which was an abandoned house. He has 3 rental units in the house, and he built a garage in the back for those units, and now he'd like to put a garden suite.
Okay, thank you. Panel members, any questions?
Sure, I had a question. Go ahead. Just one question, Chair. To the speaker, has the applicant owner read the planning report and the 2 conditions that are being imposed by planning? And does she or he concur with those 2 conditions?
Yes, sir.
Thank you.
Okay, thank you. Any other questions or discussion? Okay, is someone ready for a motion?
Sure, I think I'm going to try. This is my first meeting, so I'll be the first one to deal with item number 1. What we have before us today is a proposal to construct a second-story garden suite above an existing garage. The applicant, in order to complete that and accomplish that, the applicant requires 5 variances. We have a report from planning dated October 12th, wherein planning explains their position on planning issues and what their concerns are. We have no report from Urban Forestry. We have an advisory report from Metrolinx, which I suspect the agent has read, and there are no conditions tied to that. So with respect to the 5 variances that are being requested, the first variance relates to total floor area, and the total floor area that's required is 60 square meter. The applicant is requesting 67.4. The side yard requirement, 1.92. The applicant is requesting a small variance of 1.19. And with respect to the rear yard setback of 3 meters, the applicant is requesting 0.41. In planning's view, those 3 variances are not significant, and I concur with the planning report that the 3 variances related to the total floor area, the side yard, and the rear yard are acceptable. With respect to the angular plane 4 and 5, there's no real substantive impact related to those two. So, Chair, I'm prepared to move approval of this application subject to the two conditions stated in the planning report of October 12th. And I think the applicant does understand that the committee's approval of this is tied to those two conditions. Chair, move that the application be approved.
Thank you, Mr. Gully.
Mr. Chair, I'll second that motion.
Thank you, Mr. Taylor. All in favor? Thank you. Your application is approved unanimously.
Thank you very much.
Our second item of the day is number 413, the Kingsway. This is an application to legalize and maintain an addition at the top of an existing cabana in the rear yard. There is one variance being requested. Planning is recommending refusal of the application, and we also have a number of objection letters listed from, I believe it's a total of 4. And the applicant agent is Mr. Addison Milne Price. Welcome.
Good morning, Mr. Chair. Oh, sorry. Good morning, Mr. Chair. Good morning, fellow committee members. My name is Addison Milne Price. I'm a planner at Design Plan Services located at 900 The East Mall, Suite 300, here on behalf of the owner today.
Given that we have some opposition on this, I think it would be appropriate for you to do a presentation to us.
Absolutely. As mentioned by the chair, this is an application for one minor variance to the zoning bylaw. The size and location of the subject ancillary building is compliant with the requirements of the zoning bylaw, and relief is only required for the height of the building. Now, planning staff and some of the objection letters have pointed out the percentage difference between the permitted height of an ancillary structure and the proposed. However, a purely arithmetic approach to evaluation has the effect of removing context from the assessment of the application. As a planner, when evaluating whether the proposal fits with the existing context and whether a specific variance will have an impact on adjacent neighbors, I cannot only rely on an arithmetical approach. I must also evaluate the application from a qualitative perspective. Now, in this case, due to the way the zoning bylaw interacts with the unique grading configuration on the lot, the proposed height of the ancillary structure will be perceived as less than the numerical value as indicated on the variance. More specifically, this is due to the difference between the finished grade and the average grade on the subject property, specifically as it's perceived from the adjacent neighbor at 411 the Kingsway. The average grade, from where the height measurement is taken, is located approximately 2.5 feet below the ground. Furthermore, the ancillary building can be separated into 3 distinct parts: the exterior walls, the sloped roof portion, and an architectural feature at the top of the building. And when considering the height as it will be perceived from the bottom of the building to the top of that sloped roof portion, the height and any associated impact is significantly less than what the variance suggests. It measured at approximately 5 meters and 1 centimeter from the ground. Now, the remainder of the height relief requested is due to that feature, the cupola, on the top of the ancillary building, which has extremely minor impacts in terms of massing or shadow. The subject property and the area around the subject property is also quite unique. The size and configuration of the subject lot is quite large. For reference, the minimum lot size in this area is 555 square meters, and the subject property has a lot area of 4 times that size, at about 2,267 square meters, which is about half an acre of size. Furthermore, the property is in the unique situation of having no rear neighbors, which significantly reduces any potential impact of an ancillary building's height. As demonstrated by the tree photos included as part of this application, as well as the photos that were sent in by the neighbors in their objection letters, the boundary between the neighbors at 411 the Kingsway is currently screened by significantly tall trees, a hedge, and 411's ancillary structure on the opposite side of the lot line. This further mitigates any massing impacts that will be felt by this raised cupola on top of the ancillary building. Now, with respect to the concerns regarding precedent brought up by planning staff, Policy 145C does speak to prevailing heights, massing, scale, and density, but it does not speak specifically to ancillary building heights, and this is key. This unique stretch of the road, with a focus on larger single-attached buildings, is seen especially so on the west side of the Kingsway. The east, my mistake. While there are limited examples of ancillary building height in the area, this is pointed out by the neighbors, there are several examples of buildings with quite large building depths that are similar to or extend past the depth of this ancillary building. Note that the cabana's depth is 35 meters from the front yard setback. And the following buildings, such as 431 the Kingsway, have a depth of 42.1 meters. 423 the Kingsway has a depth of 33.82 meters. And 425 the Kingsway has a depth of 28.13 meters. Based on this justification, it's my opinion that the proposed minor variance will have minor impacts despite the apparent difference between the proposed and the required in the bylaw.
Thank you. Thank you, Mr. Milne-Price. We have several speakers online, I believe.
That is correct, Mr. Chair. We have 3 speakers.
Is Ann Anderson the first speaker? Or?
That is correct, Mr. Chair, and they are present on the call. The other 2 folks are present.
Okay.
Ann does note that they want to be on video. Ann, is that still the case? Would you like to be on video for your presentation?
That's fine, whatever you can do.
I can put you on there, no problem. Just give me one moment. I'm going to move you to a panelist where you'll be able to start and stop your own video yourself. And that button is right near in the bottom center of your screen. And then I'll go ahead and I will unmute you. Okay, so you are unmuted, Ann, so you can start speaking. You know, it does not appear you've turned your video on yet, but it's okay, technically.
I did hit it.
We don't see you on our end yet, but...
Just one sec, I hit the wrong button. And it doesn't matter to me if I'm on video or not.
Okay, well, if you'd like to start then.
I'll try one more time.
Can we get the name and I know I have it on my list, but just for the record, name and address.
Good morning. My name is Ann Anderson. I live at 17 Elstree Road, just around the corner from 413 the Kingsway. I will be brief. In terms of context, can you hear me?
Absolutely.
Absolutely.
Can you? Oh, great. In terms of context, the applicant has chosen to ignore a 2021 Committee of Adjustment ruling that permits a cabana on his property 4 meters high. Apparently, he didn't like the committee's ruling and instead built a structure 7.55 meters. If the excess were simply a matter of a few inches, I might be inclined to say, what the heck, just legalize it. But it's nearly double the permitted height. It is neither due to human error nor an accident. It's intentional. Now he's come back for a second time seeking forgiveness. Asking for 2 rulings on the same variance wastes taxpayers' time, money, and resources. More importantly, it interferes with the principles of making thoughtful and sound planning decisions. What's the point of following a rigorous process to make a ruling and then not upholding it? I respectfully ask the committee to enforce its original decision. Make the applicant comply with the original decision. Ask him to remove the offending height. Send a strong message to others contemplating something similar. Residents need to know that the planning process indeed has teeth and that the rules will be enforced. Thank you.
Thank you. Any questions from panel members? No questions? Okay. Our next speaker then, which is Matthew Aaron Dusk.
Yes, good morning. Good morning.
Good morning, sir. Can we just get your address as well?
Yes, my name is Matt Dusk. I'm the owner of 411 the Kingsway.
So you're immediately next door.
I'm right next door, yes.
Yep, thank you. Always good for context. Please go ahead.
Thank you. So I've submitted a comprehensive objection letter for your reference. It's right up there. And I'm going to be drawing on some of that today. In the beginning, we were supportive of our neighbors' building plans, which included several significant variances for their home, including a 4-meter high cabana. However, they proceeded to build a 7.55-meter cabana without any prior communication with us or the city, almost doubling the legally allowed height for an ancillary building. Our efforts to mediate and find a resolution went unanswered. They continued to build, which brings us to this formal objection. So it's essential to mention that the city's planning report supports refusing this variance, echoing our concerns. And now I'd like to focus on 2 critical aspects of our objection on page 2. The first revolves around our neighborhood's president and maintaining the official plan's intent. To illustrate this point, we conducted a thorough review of past COA approvals within our area, spanning approximately 700 meters to the south and 1,300 meters to the north of the property. Going back as far as 2007, we found over 270 previous decisions where only 4 properties obtained minor variances for ancillary structures taller than 4 meters, the highest being at 4.57 meters, which is 600 meters northwest of the property. The limited number of approvals has set a clear standard for ancillary building height in our community, a standard upheld by the planning report, which indicates that no approvals for the requested variance have been granted on the street or surrounding neighborhood. Now, when you look at the photos on page 5 and 6, you can see the profound visual impact that this structure has on our property. The 7.55 meter structure obstructs our view and honestly resembles a prison watchtower that exerts a dominant presence on our property. Also, the introduction of the flat roof at 5.72 meters substantially increases the overall mass of the structure, giving rise to my concerns regarding the future applications in our neighborhood. It's crucial to emphasize that the current application departs from the fundamental intent and purpose of the zoning bylaw, which is designated to regulate the overall mass of structures through the careful control of both height and built form. Moreover, what I've been going through, I'd like to bring to the committee's attention a matter of concern that only surfaced last night. All of a sudden I go on the portal and a shadow study is posted. What's more baffling is this omission of data for June at 9 p.m., a crucial time in the summer where shadowing is at its peak. The time period from 6 to 9 p.m. represents the prime hours when most people enjoy their backyards. Anyway, we've lived with this big structure for the past 4 months. We know where the shadowing is. The omission seems at best misleading and at worst designed to conveniently deceive the true impact of this huge structure on our property. Nonetheless, it's crucial that we stay focused on the facts and not let these manipulative tactics divert our attention. I believe that the application fails all 4 tests, the essential tests. Number 1, the 89% post height variance is far from minor. We've established that a 13% deviation has been the largest since 2007. Number 2, it doesn't align with planning and public interest. Number 3, it clearly diverges from the zoning bylaw's intent to ensure that new development will be compatible with the physical character of established residential neighborhoods. And number 4, it contradicts the official plan 4.15 section C regarding the prevailing heights of massing and nearby residential properties. So in conclusion, we request your thoughtful consideration for our neighborhood's established character and protect its future. I urge you to refuse this application in alignment with city planning staff's determination that the approval of this height variance will set a negative precedent and the application be refused. Thank you.
Thank you for your presentation. The next speaker, I'm not sure if it is Christine or John Gilmore.
Mr. Chair, we have Christine Gilmore. Christine, you're unmuted and go ahead.
Welcome.
Thank you. Thank you. Good morning, Mr. Chair and respected committee members. I'm Christine Gilmore. My husband and I live at 409 the Kingsway, just 2 doors down from the
Ms. Gilmore, sorry, your address, I believe, is it 409 the Kingsway, just so we can get...
Yes, we're at 409.
Thank you.
Yes. Just 2 doors down from the applicant's property.
Just on the other side of the previous speaker, okay.
Yes, we're next door but 1 to the applicant.
Okay.
We object to the applicant's request to legalize their 7.55 meter cabana. It's a mind-boggling 88% increase from the bylaw, as highlighted in our written objection. In June of 2023, we first became aware of the structure's construction in the backyard of 413 the Kingsway as it rose through the trees. After reaching out to our immediate neighbors, Matt and Cora Dusk, at 411 the Kingsway, it became clear that this structure vastly exceeded the 4-meter approval that 413 the Kingsway was initially granted. This 24-foot cabana is massive. When we're in our backyard, we can see it stick out above the trees. And when the sun sets, it creates big shadows on our neighbor's property. It's hard to miss and is very much out of context. We don't see the base of the cabana, we see the height. We have bylaws in place for a reason, to preserve the character of the neighborhood. As mentioned in the community planning letter, no approvals for this kind of variance have been granted by the Committee of Adjustment on our street or in the surrounding area. It begs the question, what is the purpose of bylaws if people simply disregard them? If 7.55 meters is approved, that being a 3.55 meter excess over the bylaw, where does it end? 10 meters, 11 meters, perhaps even 12? Is such extreme height really necessary? Change is inevitable, but we must respect the city planners who establish bylaws to ensure neighborhoods are protected from excessive development. We've been longtime residents of our house with ongoing construction surrounding us, first to the west and now with 2 homes north and east of us. The residents at 411 the Kingsway adhered to the bylaws, communicated with us, and behaved as good neighbors do. The 2 other homes, we hope, will do the same. If we start allowing these giant structures, we're sending a message that says, hey, build as high and as big as you want, and no rules apply. The time and energy invested in this matter has not only impacted our neighborhood, but has caused us considerable stress. We can sincerely request that during your application review, you take into consideration the points we've raised and make a decision that respects the bylaws and prioritizes our community's best interest. Thank you very much for your time.
Thank you, ma'am. Any questions from panel members? Mr. Gilly?
Thank you, Chair. Ms. Gilmore, you're at 409 the Kingsway, 2 properties over from 413. At grade level in your backyard, can you see the top of the structure?
Yeah, our backyard is it's terraced down. And so it's a bit hard to, we can see it at every single level. The worst being at the main use level in our backyard, which is when it first came to our attention. And we approached Matt and Cora and said, my goodness, what is that? Yes, it's very much in view.
Thank you.
Is there anyone else online or in person to speak to this item?
Mr. Chair, no one else on our list of attendees virtually, but maybe if anyone wants to confirm there's nobody else in the chambers that would like to speak to this item? No, Mr. Chair.
Okay, then I'll ask Mr. Milne Price to come back for a rebuttal.
Thank you, Mr. Chair, and thank you to all of the neighbors that had a submission to give. Firstly, I'd just like to, excuse me, address the issue that is brought up in terms of the after-the-fact nature of this application. By no means was an original committee decision ignored. The previous committee decision, as included on the submission materials for this application, was an approval. And I'll note that the very fact that we are here discussing this application lends itself to the fact that we are following the rules and that the bylaws do have teeth. If the decision of the committee is to refuse the application, then of course the owner will be forced to remove the structure, and instead a 4-meter structure will be constructed in its place. Now, in terms of the specific objections of the neighbors as it relates to the variance, there are indeed limited examples of precedents for ancillary structures that are taller than the permitted bylaw. However, I would point out, as I said in my original submission, that precedent cannot be the only determination of whether a variance is minor or whether it meets the intent of the zoning bylaw or official plan. As I noted, 415 does not specifically speak to ancillary structures, and this is an area of the city that has significantly large houses and structures in the rear yard. In terms of specific impacts to the neighbors, I'll point out that none of the neighbors, either 411 or 409 the Kingsway, produced a photo of the ancillary structure from the ground level of their yard. The photos are all from a second story, and you'll note that there are trees screening that balcony, from the balcony screening the structure. To me, that lends itself to the fact that it is difficult to show any other impact from the ground level without going above at an elevation. With respect to the shadow study that was submitted, the shadow study was prepared as a result of the planning staff report that spoke to a potential shadow impact on the property. Planning staff, as far as my knowledge, did not prepare a shadow study, and concerns as it pertains to shadow were not brought up to us. However, when we reviewed the study, I, in my opinion, found that there is limited to no impact as it relates to shadow from this variance on the neighbor's yard. Now, I believe that addresses all of the issues raised by the neighbors. I'll note that the neighbor at 415 the Kingsway did not make any objections. Although there is a photo from the objection letter of 411. In their letter, there is a fence between 415 the Kingsway, and therefore that photo is not from the yard of 415. If committee has any other questions, I'm happy to answer them, but I believe that addresses the concerns brought up.
Thank you, Mr. Milne-Price. Any questions from committee members? No. Thank you, sir. I guess we'll take it into committee for discussion and or motion. Mr. Taylor?
Yeah, I'll just make a couple of comments on this and see what my colleagues think, but my overwhelming thought on this is that people have an expectation and a right to consider the provisions of the zoning bylaw, perhaps in their decision to buy in a neighborhood or even if they're already there. They do have that expectation and right to consider the zoning provisions and the impact of any minor variance that might come forward. So that's obviously why we're here. Is this variance minor? My thought is it isn't. I'm concerned that there aren't precedents and we could be creating one. I also feel that neighbors' comments have a huge bearing in my mind on whether a proposal is desirable or appropriate. And we certainly heard neighbors' opinions today that it is neither desirable nor appropriate. So my inclination is to not support this application, but I'd certainly like to hear from Mr. Gully and Ms. Ruddick and you, Mr. Chair.
Thank you, Mr. Taylor. Anyone else?
I certainly share your concerns, and I'd be prepared to second if you were proposing a motion in that regard.
Chair, would you like to take it to a vote if we have a motion?
If we have a motion, that would be great.
I too, Chair, feel that the variance that's being requested with respect to height is a bit excessive. I'm not sure whether the impact is that great, but indeed on neighboring properties, particularly visually, given the foliage and so on. But I think in this, at this particular case, I think the height is excessive. And I concur with the panel, the other members of the panel, that it really does not meet the intents and purposes of the official plan and zoning bylaw. And so I'm prepared to hear a motion if someone has one.
I just would make one comment since I was requested to make a comment. You know, we have a negative planning report. We have neighbors in opposition. I don't see any support from any of the other neighbors. So based on that, I would concur with my colleagues. If anyone's ready for a motion.
I guess I started things off, so I'll make a motion. Yeah, I think what we've said is sensible and reasonable and appropriate. This variance is not minor. It's not desirable or appropriate development or use of the land and or building, as evidenced by neighbors' comments and the community planning department. I don't believe the general intent and purpose of the zoning bylaw or the official plan are maintained by this proposal. So on those grounds, I move refusal.
No second.
All in favor? Okay, the application is refused unanimously. Okay, our next application is application number 3, which is 26 GRASSPOINT Crescent. This is an application to legalize and maintain a rear yard covered deck. There is a total of there's actually one variance being requested in this application. I believe we have a speaker in opposition, and I don't think we have anything from any city departments. The applicant or agent is Anthony Bartolini on video.
Mr. Chair, audio only.
Audio only, okay.
Hello, members of the committee. Can you hear me?
Good morning. Can we just get your name and address for the record, please?
Sure, yeah, no problem. My name is Anthony Bartolini. and I'm the registered agent for my clients at 26 GRASSPOINT.
Okay.
I could just do a brief presentation if you guys would like.
Yes, please.
Awesome. No problem. Thank you. Thanks for taking the time to hear my presentation. Today we are asking for a minor amendment to the lot coverage bylaw in relation to a covered deck, as stated in the staff report. We believe the variance that we are requesting is quite minor in nature, as we are only exceeding the total lot coverage by 0.23%, which ends up being 1.17 meters squared in total. During the application process, we have prepared all the requirement documents, including professionally engineered drawings, an architectural site plan, an updated survey, which represents exactly what has been done on the site. Although we understand that we have favorable comments from our neighbors, we understand there's also one neighbor who's opposed to the application and the proposal. And today we're happy to answer any questions that that neighbor may have or that the committee may have. And we're glad to clarify during today's hearing in accordance with any questions. But that being said, I think the proposal is quite straightforward, and we hope to get a favorable response from the Committee of Adjustments today. Thank you very much.
Thank you, sir. And my apologies, I forgot to mention there is a support letter as well, as you pointed out. I have two brief questions before I turn it over to panel members, if I may. What is the height of the structure? I'm assuming you're below the 4 meter because there's no variance for the height.
Yeah, I'll just have to check back on the drawings here. So the height of the structure is 11 foot 11 inches to the top of the roof point, and yes, you're correct. There was no variance for the height specifically.
Okay, thank you. And my other question is, what percentage of the backyard is soft landscaping? I'm assuming again it's at least 50% because there's no variance for it.
Correct, exactly. On the proposal as shown, we are. I would just need to confirm that. It looks like we have about 68% soft landscaping, so we're just a little bit over what's actually required.
Perfect. Okay.
So we're proposing slightly more than.
Okay. Thank you very much. And we have a speaker in opposition, and I believe Lily or Suzanne Botovic? No? Oh, so they're not? Okay. No worries. Thank you very much. It's your choice. Thanks. Okay. Okay. Any questions from panel members of either of the applicant then? Okay. We'll take it into committee then for discussion and/or decision.
Chair, I'm prepared to speak on this item. I have carefully reviewed the application before us. I've also taken care to assess all of the points under the Planning Act that this application should be considered under. There are 4 tests that need to be assessed individually and collectively. If one of the tests fails, then the application fails. We have one variance before us. The variance is with respect to lot coverage from 33% to 33.23. Very small difference. I had the opportunity to actually visit the site because I read all of the correspondence in the file, and I was really concerned about some of the comments that were made in those correspondences. I wanted to ensure that I was assessing this application in proper manner. I took the liberty of attending on the site, getting permission from the owner to access the rear yard, and I did take a look at the structure itself. Besides the numerical values, I wanted to see the structure and the visual impact. Having done that, having carefully considered the tests under the Planning Act, having also understood that planning has no concerns, no comments were submitted by planning. I did review the orders to comply and why they were there. I also looked at the letter of support from number 28. I certainly looked at all the letters of objections from number 24 and carefully considered every comment. And having done that, Chair, I'm prepared to move approval of this application because I believe that the scale and the character of what is being requested is nominal and it meets the test. So I move approval with no conditions.
Thank you, Mr. Gully. Do we have a seconder?
I'll second that motion, Mr. Chair.
Thank you, Mr. Taylor. All in favor? The application is approved unanimously. Thank you. Actually, if we could take morning recess. I know it's only the fourth item, but we've been at it for a while. 5 minutes?
Mr. Chair, why not right to 11 o'clock then, 10 minutes? We'll reconvene at 11. It's 10:49 now.
Okay, thank you.
Perfect.
Thank you.
Thank you. All right, Mr. Chair, members, attendees. It's 11 o'clock, so maybe we'll look to start up with item number 4, 11 Kings Mill.
11 Kings Mill Road, and this is an application to construct a new detached dwelling with a detached garage. There are a total of 7 variances being requested. There has been revisions to all 7. All 7 have been reduced. Planning was originally requesting that variance 4 be refused. We also have an arborist report, and we have recommended conditions from the TTC for comment. And forestry, we're just discussing, we're a little bit confused. Maybe the applicant can clarify this for us. Was originally requesting condition 1 and 2, which is public and private trees, but there's a letter saying no conditions. So I'd like to get some clarification on that. And Mr. Engelman, welcome.
Yes. Good morning, Mr. Chair, committee, staff, and the public. Thanks for having me. David Eagleman, Design Plan Services, Inc., 900 The East Mall. And through you, Mr. Chair, before I get into my presentation, if you would like, I can run through the revisions, although I did provide a cover letter and staff did create a revisions letter, so I think it's quite clear, but if you need me to, I can.
I think we're good.
Okay. So through you, Mr. Chair, I'll get right into my presentation considering staff comments, and I can address the comment about the forestry letter after. So before getting into the variances, I would like to note that we have consulted with planning staff regarding this application and have made a number of revisions to the proposal in an attempt to satisfy and address the concerns raised. And although these revisions have addressed most of planning's concerns, planning staff are still not satisfied with the proposed south side yard setback and are recommending refusal of that variance only. I respectfully disagree with the position and will address this in speaking to the proposed side yard setback variance shortly. I have reviewed the memo from Urban Forestry regarding this application, as well as the memo from the TTC, and am agreeable to all the recommended conditions. The Forestry did issue a letter that seems to be quite new in terms of their process, advising that no conditions are recommended, but there are tree injuries and removals, so should the committee find it necessary, the committee may impose condition number 1 and 2 as per the forestry memorandum. I will note that we also have obtained and submitted signatures in support of the proposal from adjacent and surrounding properties. Specifically, both immediately adjacent neighbors at 13 and 9 Kingsmill Road are in support of the proposal. Some of these letters were provided to the committee after the material submission deadline, so they may not be within the committee's package. However, they have been provided to committee staff and they are on the public record. So regarding the variances, and I will note just in case I run out of time in respect to speaking to the variances, I did provide a detailed cover letter addressing all of the variances, so I would hope that committee has reviewed that letter. So first I'll deal with the side yard setback variances, considering that is really the variance at issue according to planning staff. Both the north and side yard setbacks have been increased to 0.91 meters and 0.76 meters respectively. And both neighbors on the immediately north and south sides are in support of the application. The proposed north side yard setback of 0.91 meters is actually an improvement to the existing condition on the north side, as the existing dwelling has a north side yard setback of 0.76 meters at its widest point and 0.44 meters at its narrowest point. The proposed new dwelling will provide a more consistent, larger setback on the north side of 0.91 meters. And regarding the south side setback, the proposed south side yard setback of 0.76 meters is measured to the proposed carport, which is supported by only columns and the cantilevered living space above the carport. However, the living space above the carport is actually 1.422 meters set back from the south side lot line. So really, the variance only pertains to the carport that is supported by columns with no exterior main walls. The proposed carport accounts for only a portion of the south side main wall, whereas the remainder of the south side main wall is set back 3.97 meters from the south side lot line, which is 2.77 meters larger than the minimum required south side yard setback. The adjacent dwelling at 9 Kingsmill Road has an existing north side yard setback of 0.9 meters for the entire length of the north side main wall, which is the side that abuts the subject property. And moreover, there have been a number of approvals, but considering I've spent most of my time speaking about the south side yard setback variance, I don't really have time to get into the other variances. As I mentioned, I did provide a detailed cover letter. I would hope the committee has reviewed that. And based on the provided justification in my cover letter and in my presentation, I am of the opinion that this proposal fits in with both the existing and planned context for the neighborhood, is consistent with the redevelopment trends along Kingsmill Road, as well as the broader neighborhood context. And for these reasons, I believe this application represents good planning and meets the 4 test under section 45.1. I'm happy to answer any questions.
Thank you, Mr. Eagleman. Any questions from committee members? Mr. Taylor?
Yeah, thanks, Mr. Chair. Yeah, Mr. Eagleman, in your conversations with the Community Planning Department, did they ever give you a number that they would be happy with regarding the south side lot line?
Through you, Mr. Chair, planning's recommendation was to eliminate the carport and the living space above it. So effectively asking us to be above compliant with the minimum south side yard setback, considering if we eliminated that, the south side would be 3.97 meters set back from the south side lot line, which is, again, 2.77 meters larger than the minimum south side yard setback.
Yeah, thank you.
Mr. Gully?
Thank you, Chair. Mr. Eggleman, good morning. I was wondering if you might be able to reiterate the comment justification that you made with respect to the 0.76 setback, that applies only to the unit cantilever part of the proposal?
Yes, through you, Mr. Chair. So to address your question, Member Gully, the setback on the south side of 0.7...
I think it would be helpful if we could get an elevation. I think that makes it very clear.
Yes, thank you, Mr. Chair. I agree. And just while that's being pulled up, to address your question, Mr. Gully, the south side yard setback of 0.76 meters, which is the variance for the south side, is measured to the carport on the at grade. The living space above the carport is actually compliant with and exceeds the minimum south side yard setback requirement, as the living space above it is at 1.422 meters. So the variance is only to the carport, which has no exterior walls. It's supported by columns and only makes up a portion of the south side main wall.
So is it 1.442 or 1.42? Makes a lot of difference.
Yes, through you, Mr. Chair, so the living space above the carport is set back 1.422 meters.
And the residents on the the residents on the south side of this lot have not submitted any comments or objections. They understand what's being proposed here.
Through you, Mr. Chair, the neighbor on the south side has actually supported the application. At 9 Kingsmill Road, a support letter was provided just last night, so it may not be within the committee's package, but again, it is on the public record. I believe I sent it to Mr. Wills.
Thank you, Mr. Eggleman.
Thank you.
Thank you. I believe there are no other questions, and we have another speaker as well.
That is right, Mr. Chair. We have a virtual participant.
Vicky Sharp.
That is correct, Mr. Chair. Vicky is asked to be on video for her presentation, so I've gone ahead and made Vicky a panelist. Vicky, you can go ahead and start your video if you'd like, and I will go ahead and unmute you. Go ahead, Vicky.
Good morning.
Good morning. I do see
Welcome.
I do see your video is on, but you have something covering the video itself, so we can't actually see. There we go. Okay, one moment. I'll only put you on the let me put you on the stage, and you'll be good to go now. Wonderful.
Super.
Okay.
Yeah, thank you very much, and thank you to the committee for providing this opportunity for me to address you. I also would like to mention that it took me some difficulty getting hold of the materials, and city staff were extremely helpful, so thank you to them.
Sorry, if we could just
I live at
confirm
12 Kings Court Drive. I am on the property that is immediately east of the proposed application, with 11 KINGSMILL directly backing onto my property and overlooking my backyard. And I do not support this application in its current form. All of the variances that are stated are excessive, even with the last and more recent changes and some reductions. We're seeing 40% in excess of the variance for lot coverage and gross floor area, 48 and 49% for side yard setbacks. Dwelling length is over by 17%, and the permitted platform by 25%. None of these, from a technical perspective, are small. References in the cover letter sent by the agent, DSP, refer to other large variances that have been approved in the neighbourhood. All but one of them are still less than the current request as modified for 11 KINGSMILL. I also want to raise the support that is in the neighbourhood for not approving this. There is a misleading statement in the letter of the 16th of October that said that they have not been made aware of concerns raised by surrounding neighbours. I am a surrounding neighbour and raised concerns with the owner applicant many months ago, and also was there with another neighbour and would not sign a support letter. I was very clear that I did not want a second-storey platform at all, nor to lose all the shade provided by the trees. There are 4 neighbours in addition to myself who are in the immediate neighbourhood who have not signed support for this, and of those, 2 of them have made written submissions and 1 is out of the country. So I think it's misleading to say there is general support. I also find it rather strange, some of the references to if we left out the 3rd floor, then it would all be okay. The side yard setbacks, essentially we're looking at things that have occurred where these kind of close variances have been approved. We're seeing, because of the sandy soil in this neighbourhood, collapse of driveways. We've seen costs incurred to try and fix those up. We've even seen one property that fell into the hole, and we are seeing damage to cars and property of snow and ice coming off the building when you're so close to the lot line. And I would just say that planning, after all the changes, has still said that these setbacks are not common for the street, and they are of the opinion that the south side setback does not respect or reinforce the prevailing character of the neighbourhood and does not meet the intent of the official plan and zoning bylaw, which obviously I fully support. The back has a 3rd story. It's written in the letter that it's not perceived from the street. There are 2 windows on the 3rd floor at the top and 3 at the back. But the platform, obviously I prefer none, but if you could please stick to the actual requirement of 4 meters rather than approving a 25% increase. The more space, the more people are likely to be there, and that will interfere with my enjoyment of my property. I do think that there needs to be more attention paid to the forestry, and although there are some trees I will certainly agree need to be taken down. The black walnut is a protected tree and should be replaced with trees. Buying your way out and not replacing shade trees also affects the neighborhood. I do have a question though. First of all, there's commentary about the fact that the third floor, a lot of it is not livable space. Is the roof structure on the third floor such that only the so-called mechanical room isn't livable? Or is it actually just some designation that can change later? So I have a second question. There was an original commentary that there would be commercial use of the property. It's not clear to me whether that is still remaining and if there was a zoning request for that. But my overall comment is that I feel that this is not in keeping with the neighborhood, and we've seen and experienced as neighbors problems that arise from these kind of excessive variances. Thank you.
Thank you, Ms. Sharp. Any questions from panel members for the deputant? Mr. Gully?
Thank you, Chair. Just a couple of questions, Ms. Sharp, just to help me out. With respect to the variances then, what we have before us today, the 7 variances, are you particularly concerned with the setbacks in variance number 3 and variance number 4? And I'm asking if you can help me out with the variances, not necessarily with respect to the soil conditions or with respect to speculation of what the third floor may be, or with respect to the commercial, just trying to focus on the 7 variances before us. Other than 3 and 4, which you talked about setbacks, are there any other specifically that concern you?
Yes, thank you for the question. In particular, it would be variance that I have listed as number 7 on the public notice, which is the permitted platform on the 2nd story. It is still 25% greater than the normal 4 square meters. They're requesting 5. And I am very concerned, as I live in my home and don't have multiple properties. I spend a lot of time in my backyard and don't wish to be overlooked. The height of it is such that I have neighbors who are also will be overlooked, who have expressed concerns on this one.
Thank you so much.
Thank you.
Anyone else? Okay, thank you, Ms. Sharp.
Thank you.
If we can get Mr. Engelman back.
One moment, Mr. Chair, while I remove Vicky from a panelist.
Sorry, I should ask if there's anyone else. I'm assuming there's no one else present to speak on this issue. No, okay, thank you.
Yes, through you, Mr. Chair, to address some of the comments made by the neighbor, and I appreciate the comments made. I'll note that at the time of writing my cover letter, I was not aware of any concerns or objections. I did not intend to mislead, and actually I'll note that the objection letters, the 2 objection letters that I have seen, were uploaded to the city's AIC last night or yesterday. They are dated October 25th. So that was after the material submission deadline, and the committee may not even have them within the package. So I did not try and mislead anyone. Regarding concerns with the trees, all the trees being proposed to be removed or injured are within the as-of-right envelope. And the fact that forestry has no concerns with the application and has recommended standard forestry conditions is a testament to the fact that those tree removals are not a result of the variances being requested directly. And just to clarify the questions from the neighbor as well, there is no commercial use within this proposal. This is a single detached dwelling for residential use of a single family or occupant. And regarding the habitable floor space in the 3rd floor, the 3rd floor is proposed as a mechanical and storage room, and there's additional unhabitable space that's part of the attic within the 3rd floor. So the floor plans accurately depict what the intention with the 3rd floor is. There is windows facing the rear yard within that 3rd floor, but it is a mechanical and storage room. And I'll note too something important, that this neighbor at 12 Kings Court is actually, and you can see it in the map here on the screen, that she is sort of offset to the subject property, whereas the other neighbor at 10 Kings Court is also backing onto the backyard of the subject property, and I am not aware of any concerns or objections from the neighbor at 10 Kings Court. And I'll also note that the dwelling itself is 15.37 meters set back from the rear property line, which exceeds the minimum required rear yard setback by quite a large margin. So the proposed new dwelling is going to be quite far away from the neighbor at 12 Kings Court Drive. And frankly, the main concern, from what I understood from the neighbor's letter and what was mentioned today, is the variance pertaining to the platform area. We are asking for 1 additional square meter. That is, in my opinion, the most minor variance being requested today, and frankly, it has little to no impact over and above what is permitted as of right. If that platform was reduced by 1 square meter, it would be permitted as of right and would be permitted in the location that it is. And again, I can go through the other variances, but I think I speak to them in quite detail within my cover letter. So the cover letter speaks to the justification regarding all the other variances, and in my opinion, the proposed dwelling fits in with the neighborhood. It is in keeping. The design is very much in keeping with the Kingsway neighborhood, and the architect who prepared the design is very familiar and sensitive to this neighborhood. We did provide a colored front elevation to show what the dwelling would look like. I hope that made its way into the committee's package, and it fits very well in within the neighborhood. So those are my comments, Mr. Chair. I'm happy to answer any additional questions.
Thank you, Mr. Eagleman. I have some questions, and I'm sure the panel members will as well. With regards to variance number 2, the lot coverage, do you know what that number would be if you excluded the carport? In other words, if the actual area that's touching the ground?
Yes, through you, Mr. Chair, I don't have the specific number of what the coverage would be excluding the carport, but what I can tell you is that the proposed lot coverage includes a portion of the basement below the proposed rear covered deck, because the area below the rear covered deck is excavated and part of the basement, and because of that, it gets included as part of the coverage.
Yeah, there's that, and there's this. I think for me, going from 33% to 44% is excessive and not minor. But I think there are reasons to mitigate that, and it would be helpful to know what those numbers are. Because there's the basement, and then there's also the carport, which doesn't actually occupy ground space. Because if we're dealing with drainage, that's going from 33 to 44 is pretty significant.
Yes, and through you, Mr. Chair, just to provide some context, if you exclude the basement portion, the coverage would be 40%. So then if you were to exclude the carport, again, I don't have the exact specific number, but it would be most likely very close to around 35%.
Okay, I just wanted the members to have that context, and that was really the reason for my question.
And through you, Mr. Chair, just to provide one additional number, the dwelling itself would have a coverage of 32%, which is actually compliant with the bylaw.
Okay, thank you. My other question, maybe it's premature. I'm going to save it till other members may have other questions, so I'm going to open it to the panel. Mr. Taylor?
Yeah, thank you, Mr. Chair. Mr. Eagleman, with respect to variance number 3, I noticed that the existing building on this lot has a north side lot line of 0.44 meters. And I'm just thinking a lot of concerns from the neighbor that spoke could have been resolved if that had been maintained. And I'm just wondering why it wasn't. It seems to me if you built on the existing lot line on the north, you may not need variance for. If I'm doing the math right.
Through you, Mr. Chair, I don't see how maintaining the existing north side yard would have addressed concerns from the neighbor, considering the neighbor is to the rear of the subject property. So perhaps, Mr. Taylor, perhaps you can just clarify, because I don't see how maintaining that north side yard setback would address any of the concerns raised by the neighbor.
Well, I guess my thinking is it was built on the existing lot line on the north side, half a meter less than you're proposing. You could build that identical structure that's being proposed a half a meter less on the south side. You'd slide the building to the north by half a meter and gain that on your south side lot line. Correct?
Through you, Mr. Chair, the neighbor at 12 Kings Court is more to the north, and
sorry,
to the south.
I'm not specifically or explicitly asking this question because of the neighbor. Just generally, I guess my simple question is, why didn't you take advantage of the fact that the house is 0.44 meters from the north side lot line?
Well, through you, Mr. Chair, the planning staff actually wanted us to increase the side yard setbacks on both sides. So we did that. And we felt that it would actually, providing a greater setback would appease the neighbors on the adjacent sides, which it has, considering both of them are in support. So it's a fair comment, Member Taylor, but I think there were other reasons as well why we didn't do that.
Okay, thank you.
Mr. Gill?
Thank you, Chair. I don't want to spend too much time, but you did indicate to the panel that the distance between the rear lot line and the edge of the platform is roughly 15 meters. Going back to Ms. Sharp's comment with respect to the platform, variance number 7.
Through you, Mr. Chair. So the rear yard setback to the dwelling itself is 15.37 meters. The platform extends a little bit past the rear main wall, as it's above the roof that covers the rear ground floor porch. And so the rear ground floor porch is set back 12.93 meters from the rear lot line, which is again exceeding the minimum required rear yard setback. And so the platform of concern, according to the neighbor at 12 Kings Court, is actually set back a little bit further than 12.93 meters.
And again, Ms. Sharp's home does have a depth in the rear yard as well. So the separation from that platform to her backyard is substantial.
Yes, through you, Mr. Chair, I would agree with that. And that's a good comment, because I don't know what the neighbor's rear yard setback is, but presumably if we assume a minimum of 7.5 meters, which is typical, then that would be at least a 7.5 meter plus another 12.93 meter plus or minus, or sorry, not plus or minus, plus
So I'm
separation distance.
Sure, Mr. Egelman, sorry to put you in that position. I guess my point is that there's sufficient backyard at number 12 as well that separates that property and their enjoyment of their backyard, which they have a right to. So there is sufficient separation. Where does that platform have access from? Does it have access from a family room?
Yes, through you, Mr. Chair. Thank you, Member Gully. Again, I think it's a good question. The platform is off the master bedroom. So to that effect, it's not a platform intended to be used for congregation of people or having parties on this platform. It's a master bedroom platform to be enjoyed by the occupants of the master bedroom.
So in other words, if you're inviting people to that platform, they'd have to go through your master bedroom to get to it. Is that correct?
Through you, Mr. Chair, that is correct.
Thank you.
Okay, if there are no other questions, I'd like to propose a question. In the event, should the member, and I'm not sure where the members are on this, but should they be wanting to approve this, I'm wondering whether you would be okay with tying approval to the site plan with regards to lot coverage, to reiterate the discussion we had with regards to the basement and the carport being a substantial part of the overage. And furthermore, would you be willing to tie to elevation drawings with regards to the south side setback so that it's clear that you're not getting a blanket setback to that distance, but only for the second floor?
Through you, Mr. Chair, I do not think there is an issue with that. The owner is actually here in the room today, so if I may just consult with him for a brief moment. That's okay? Thank you.
And I guess at this point, if we're, well, I guess I can't take it into committee until I get an answer. Okay.
Yes, through you, Mr. Chair, those conditions are acceptable.
Thank you. With that, I'll take it to committee, unless anyone has any further questions, so we can have some discussion and a motion.
Chair, I'm prepared to make a motion. Chair, I've had the opportunity to carefully review all the information in the file. I've also had the opportunity, in this instance, to visit the site and refamiliarize myself with this area of KINGSMILL Road. I think the application before us today has substantive changes made from the original. Substantive in terms of trying to minimize or reduce the magnitude of the variances that were originally requested. And I think the fact that planning has only commented on variance number 4, just with respect to the side yard setback, speaks a lot to me. I read the planning reports very carefully. I consider what they say. It's not necessarily what I will go from all the time, but certainly in this case, I believe that they are in support of the changes that have been made. As I said, I think substantive changes have been made, and the substantive changes that have been made are appropriate. They fit the in my way of thinking, the terms of what a minor variances are individually and collectively. I believe that the variances that are being requested are now reasonable. They may not have been before, but they certainly are reasonable today in the changes that have been made. So I'm prepared to move approval of the subject application and authorize the variances subject to urban forestry conditions 1 and 2, as they've indicated. The TTC report is really advisory. I think you're aware of that. I think there's support from the community. I listened very carefully to Ms. Sharp because I think she had some valid points to make. But I believe that variance number 4 with respect to the 0.76 setback to me is not essential in my analysis. So I'm moving approval without the planning condition.
Do we have a seconder?
Mr. Chair, if you don't mind, I'd like to propose a friendly amendment to Member Gully. Would you, sir, be agreeable to another condition tying approval to the site plan with respect to elevation drawings and lot coverage?
Absolutely.
Okay,
No problem.
On that basis, then, I second the motion.
Okay, all in favor? Okay, it's carried unanimously. Thank you.
Thank you, Mr. Chair and committee. Have a great day.
Thank you. Thank you, Mr. Engelman.
So is that tied to the site and elevation plans as it relates to coverage?
Yeah, I think what we wanted to do is to tie it to site plan as it relates to coverage, and tie it to the front, to the elevations as it relates to the side yard setback.
Well, the site plan could get that. Okay, so
Yeah,
we'll
just
do
both, just tied
as
to
it relates
both.
to coverage and side yard setback,
Yeah,
correct?
yeah, combined, sorry.
Thank you.
Okay, our next item is number 5. At this point, you'd think we'd be a little further ahead, but it's a slow one today. So this is for number 16 James Street, and it is application to construct a 2-story garden suite in the rear yard and to relocate an existing shed. There are 2 variances being sought. Forestry is asking for condition 2. There is an arborist report. Planning is okay, and transportation is okay. Both have reports saying they are okay. There is also a number of letters of support and a support petition. And I didn't see that. Oh, sorry, yes, and there are 6 objectors as well. So, oops. I believe the agent or applicant is Daniel Hall.
That is correct, Mr. Chair, and they've asked to be on video. So Daniel, I've gone ahead and made you a panelist now, so you can start or stop your video. In this case, start it by hitting the start video button at the bottom center of the WebEx.
Yeah, thank you. I have, it appears to be on here. Is it, can you see me at this?
Not yet.
At this time.
I can't see you on my end yet.
Okay, start video. Got it. Here we go.
Here we go. So I'll move.
Can you see me?
Okay, one moment. All right. There we go. Should be good to go now. Thank you.
Thank you. Thank you, Mr. Chair and panel. My name is Daniel Hall. I am the principal architect at Collaborative Architecture, Inc. of 943 Queen Street East in Toronto. I'm the applicant and the architect on behalf of the owners, Rick and Monica Dodens of 16 James Street.
Okay, welcome, Mr. Hall. Given that we have some opposition, I think we'd like to have a presentation.
Yes, thank you. So the proposal is to construct a 2-story garden suite at the rear of the owner's home. Its purpose is for them to move into it as a place to age gracefully in place, a forever home, and allow their daughter, son-in-law, and grandchild to occupy their main home. And we found this is quite consistent. About 3/4 of our numerous backyard home projects we work on have a similar rationale for multi-generational living. So there is a wide support, as you've seen, in the immediate neighborhood, and there are definitely a few objections from the wider neighborhood, in particular the neighborhood association. Urban Forestry has expressed a standard condition we have no issue with. As you've seen, we initiated the process already with an arborist report. The project has been cited to avoid harm to the trees. Transportation has also commented, and they have no objections at all with the variance, and I'll touch on that briefly. Planning has also commented that not only do they have no objections, they actually raised the point that this wouldn't even be here in front of us as a variance if one built the main house to its maximum permitted size of 222 square meters, which is a very interesting point. This is in Long Branch neighborhood, and as you may be aware, Long Branch has its own set of neighborhood character guidelines. We have submitted the checklist. We've reviewed them. I believe there are 17 of them. Only one has any question, and that is around the parking. And it, in fact, says that you should be consistent with what goes on in the neighborhood, which I will speak to in a minute. I believe we are, in fact, compliant with all of the Long Branch neighborhood character guidelines. The Objections principally seem to come from the Long Branch Neighborhood Association, which I think they note in their letter had its last annual general meeting 6 years ago, I believe in 2017. I will point out that numerous of the people who signed letters in support are members of that association, as in fact are the owners. So I'm not sure that they speak of the neighborhood in its entirety, but rather of some individual views. The question around the parking is a variance to regularize a pre-existing condition that predates the zoning bylaws, predates the time of the owners owning this property. And as you'll see from the survey, the parking pad, the driveway is entirely on the owner's property. There is no boulevard parking. There is a curb cut. Transportation has no objection. And it stems from the fact that the garages from the house of this era are quite small. The garage door is less than 8 feet wide. So the garage itself is not a valid parking spot. So we are simply asking to regularize what goes on there. And you'll see in page number 3 that we submitted in our package of drawings, you'll see photos of existing homes to indicate that this is in fact consistent with the character of the neighborhood, which is the concern in the Long Branch Neighborhood Character Guideline. The principal variance is a technical one. The garden suite, they measure interior floor area, that is the space from the inside of the wall areas, of all levels, including a crawl space. And as we clarified with the planning department, including a crawl space that's only a foot deep if it were. In our case, it is 5 feet deep. It does not qualify as a basement under the Ontario Building Code. It is a crawl space. We've been in touch with both zoning and with the senior planner, David Dreger, who's behind the garden suite file, and he's well aware that this is what he would have said a bit of a loophole, and they will be reviewing this at their 2-year mark of reviewing garden suites. As it stands, though, the bylaw says your interior floor area of the garden suite must be less than the gross floor area of the house. Gross floor area in an RD zone, residential gross floor area, is defined that it may exclude the area of the basement. And so the building department has chosen to exclude the area of the fully finished basement from the main house, arriving at a gross floor area above grade of about 97 square meters, but including the area of a crawl space that's intended for storage of mechanical equipment in the laneway suite, resulting in a much larger interior floor area. Worth noting, the interior floor area, as noted on our plans, above grade on the laneway suite is actually 96 square meters and change. In other words, deliberately designed to comply with the bylaw, the intent comparing above grade to above grade. The building is also smaller than the permitted 60 square meters, and in every other aspect complies completely with the garden suite bylaws. Angular planes, coverage, height, everything is compliant. The neighbor immediately behind, who's affected on 37th Street, has indicated their support. The neighbor at 14 James was unavailable, but you'll notice that our clients has canvassed all the immediate neighborhoods and amassed about 20 signatures in support. In fact, one of the letters of objection from Brent Campbell, you'll see from email correspondence filed with the committee, in fact, has withdrawn his objection after speaking with the client. So I'd like to argue that this, in fact, is fully compliant with official plan and zoning policies, increasing density, and we are compliant with every aspect of the bylaw that we can be, save for this technical variance of not comparing apples to apples, but interior floor area to gross floor area. You will note one follow-up point, as I noticed we started after 5-minute clock was already running, that on drawing number 5, you can see a little bit tongue-in-cheek, 2 illustrations that compare what the garden suite would look like with the variance approved and if it were not approved. And as you can see, there's no visible difference because we are talking about invisible space. Thank you.
Thank you, Mr. Hall. Thank you for that clarification. That's an interesting delineation of the square footage and the apples to apples argument. My question was going to be that should the primary residence actually have been built to maximum, and as planning points out, then we wouldn't have a variance. But I just want to point out that should it have been built, there may have been other resulting variances because then the distances may have been different. So it's not quite that clear, unless you would like to comment on that.
Well, I would comment simply that if one, as many people in this area do, rather than tear down the house and build to this full 222 square meters, but simply topped up the 1-story house with a second floor, all of the distances and other variances would remain unchanged, yet you would be adding a substantial amount, about another 90 square meters of floor area to the building.
Fair enough. Thank you. Any questions from panel members? Mr. Gully?
Just a point of clarification. Can you please explain to me what's intended with respect to the shed. It's labeled as relocated shed footprint.
Yes, through you, Mr. Chair. So there is an existing shed has been relocated. In the early stages of zoning review, they identified that it needed to be about 3 or 4 inches further away from the house. So we relocated and adjusted the plans, but the zoning examiner therefore withdrew that variance, as you will see. But for whatever reason, the description on the overall file still says to relocate shed. The shed is being relocated. The zoning department is fully aware of exactly where it's going, and we've been back and forth with them on that matter. So I do not anticipate them discovering any hidden variances here after the fact.
So the shed that's there today is not necessarily in its future location. Is that correct?
The shed is indicated where it will go in its future location on the site plan. That is part of the submitted plans, and that has been reviewed by the building department.
So the shed today that's in existence in the rear yard will be relocated. Is that correct?
Yes, it's relocated to make room for the garden suite to be constructed.
Thank you. With respect to the paving all around and to the very north of the proposed garden suite, why is there so much paving? And what kind of paving?
To be able to, yes, through you, Mr. Chair, the paving is landscaping. It is fully compliant with the soft landscaping, hard landscaping provisions, and it provides some patio space and amenity so that you can live, although one wants to be close to family, one doesn't always want to be that close. And having some private patio space on one side of the garden suite separate from what the family will have on the other side and their existing deck, the owners felt would make for a more enjoyable use of the backyard. So share when you want to share, have privacy when you want to have privacy.
Certainly, we're not going to speculate what may happen, but I wonder if you've had discussions with the applicant with respect to the possibility of introducing a new driveway onto 27th Street in line with that paved area? And just to the
So
north
through
of
you,
the
Miss.
hydro pole?
Yeah, through you, Mr. Chair, there is a hydro pole in the way there, and this would require an application through transportation for another curb cut and access over top of the public boulevard, and it is not part of this application
Okay.
to do that.
And indeed, the hydro pole lines up with the north wall of the proposed structure. And your client does understand that should he require or want or desire access, he'd have to go through transportation services for a new driveway. The reason I'm asking,
Through you, Mr. Chair, yes, we're fully aware, and hydro poles are not easy to move. In fact, I've never had a situation where we managed to get one moved. So
the hydro pole
I don't think there's much risk of that.
Excuse me, the hydro pole would not have to be moved. It could easily accommodate a 6-meter wide driveway to the north of it. The only reason I'm asking that is I noticed that the pavers are located in such a way that a car would be able to drive into it. Now, I said, we're not speculating what may happen because it's speculation. All I'm trying to get from you is that your clients do understand that if an access, a vehicular access, were to be introduced on 37th, he would require to go through a separate process and another process. Is that correct?
Through you, Mr. Chair, yes, very, very clear on that matter. Thank you.
Thank you.
Thank you, Mr. Hall. No more questions? We have several speakers. If we could just confirm who's on the line and who's not.
Mr. Chair, it appears we have every area neighbor that is interested in speaking, either virtual or in person.
Oh, okay. So let's start with the in-person then.
All right, Mr. Chair, let's start with the in-person, and that is Richard Eastwood.
Welcome.
There we go. Good morning. I'd like to thank the Committee of Adjustment for the opportunity to speak to you today in regards to the requested variances to the zoning bylaws for 16 James Street. By way of introduction, my name is Richard Eastwood, living at 14 James Street, directly beside the east side of the subject property, 16 James Street. Myself, my wife Linda, and our 3 children live there and have been there for the last 28 and a half years, since 1995. There are 3 areas that I'd like to speak to you today in regards to this file. 1, the relatively new garden suite bylaws for the garden suite to be of a smaller gross floor area of that of the main residence. In this application, this is clearly not the case, as the proposed garden suite GFA is 144.09 square meters, or 48% larger than the main residence of 97.2 square meters. This variance, respectfully, cannot and should not be considered a minor variance to the existing bylaw. The implications of potentially allowing such a variance would set a negative precedent whereby future garden suite constructions would draw on this for justification to build larger garden suites relative to the main residential home. Looking closer at the application, it refers to the addition of a crawl space for the increased GFA. I would respectfully suggest that this crawl space at 47.4 square meters with a height of 1.75 meters, or 5 feet 9 inches, could or would be used as a livable or workable space. By way of comparison to my own home, which is of the same size, era, and style as 16 James Street, my home has a basement in some areas of just 6 feet 3.5 inches, or just 6.5 inches higher than the garden suite. And I can assure you, my basement is fully used as a livable or workable space, and I see no reason the same would not be done with the proposed garden suite. In summary of this first topic, I'd like to offer the following. The variance is not at all minor in nature, and it does not conform to the general intent of the zoning bylaws. The second area I'd like to comment on today is the high risk to injure a large spruce tree to facilitate the construction of the garden suite. The tree has an estimated height of 40 to 50 feet and sits approximately 5 feet from my property line and approximately 13 feet off my garage. To install the sewer line and the water line for the garden suite, it will have to injure the tree by digging at its base to lay both of these lines. The applicant has commissioned a study for this dig, and by its own statement states, quote, "Damage to trees is cumulative and usually irreversible once it has occurred." With this dig, there is a real risk of permanent damage to the tree, or potentially in the future if repair work is required to the sewer line or water line, which would require a new excavation. We are also aware this is a concern to the city already through the Urban Forestry Division, has recommended a denial of the garden suite application because of this injury to the tree. Additionally, in this area, the same tree has a concerning and fragile history, where a number of years ago, the tree was in a dire state, as I recall from the property owner, was dying or at high risk to do so. And at the time, it required a constant and specialized feeding and watering. Lastly, if the injury to the tree is permanent, I would suggest this poses a serious and real hazard to my home and my family, given its very close proximity to my house. The last area I'd like to speak to you today is about the impact I see on my family and its enjoyment of our outdoor living space or backyard. We bought our house close to 29 years ago for many reasons at the time. And one of those main reasons was the privacy and openness of the backyard for my family's enjoyment. Already, we have seen a drastic change from the relocation in July of this year of the applicant's large shed, close to 200 square feet and approximately 12 to 13 feet in height, from the rear of its backyard to the direct east side of the yard, approximately 12 inches off my property line and directly parallel to my outdoor patio of 25 years. The impact is real to our patio for its natural lighting, the afternoon shadowing that it creates, and the shed's aesthetics, which have all impacted negatively to the enjoyment of this area by my family. With the addition of the proposed oversized garden shed, the balance of the backyard will now suffer the same impacts as the patio from a natural lighting, shadowing, aesthetic, and now privacy perspective. To allow an oversized garden suite to be built is not only contrary to the intent of the garden suite initiative, it is also to that of the city bylaws. I would like to thank the committee for your attention today and the consideration of all the 3 areas discussed, and I would respectfully ask that your decision today be a full refusal of the bylaw variances requested in this application. Thank you.
Thank you, Mr. Eastwood. Good timing. Any questions of the deputant? No? Okay. Thank you, sir. If we can go to the online deputants now.
Which one would you like to start with, Mr. Chair?
Gabe, I'm sorry, I don't want to take a chance on mispronouncing this last name.
It's okay. Gabe is actually the architect for the file.
Oh, sorry. Okay.
Yeah.
So Christine Mercado?
We can do Christina first. All right, Christine, you're unmuted. Go ahead.
Thank you. Hello, everybody. My name is Christy Mercado, and I'm the chair of the Long Branch Neighborhood Association. Welcome back, Mr. Gully. Our concerns are basically policy-based. So garden suites are still in a study phase end, and as of June, we have not reached the 200 suites or the 2 years to trigger a city study. So the technical problem that has been identified about the different measuring of garden suites versus the house, there were reasons for that, and we did identify this as a problem during the study phase of garden suites before the policy was even put together. But anyways, we are where we are. Basements are permitted. We have asked for an update from Etobicoke York Planning on when to expect the city study on sort of the feedback on where garden suites and what variances people are asking for on a citywide basis, because there is no way for residents to track this. Now, our concern is the precedent of approving a garden suite that is larger than the home, and we're not entirely unsympathetic to the applicant. Downsizing from your home is difficult, and basements are permitted for the garden suites policy, but they are very clear that they are supposed to be subordinate to the home. And we have to remember that what's being applied for here is the large end of garden suites. So garden suites are actually permitted on most properties in Long Branch, including ones of a much smaller configuration, assuming that considering that the garden suite would actually be correspondingly smaller. So in telling them they would end up being smaller, more efficient, furnaces and hot water tanks would fit in a closet, as opposed to turning on the need for space occupied in a basement. So as far as storage goes, there are options that could be outside the home. So our concerns definitely lie in the records of decision. So if approved, the nuances of approval are not documented, but are added to a list of decisions that establish a precedent that garden suites should be bigger. And right now, they're already big, and in this particular case, bigger than the main house. So like I mentioned before, we do have limited data. There are only 2 garden suites in the neighborhood that we're aware of that were built of as of right, and that's on page number 7 in my letter, and it is clearly subordinate to the main house. Just keep on going. Okay, so you've got, back up, next, previous page. Thank you. Okay, so it's a triplex with garden suite peeking out of the back. So if you go to the next page, you get a side view of it. Okay, and it is a little bit skewed because you can only get sort of what it appears from the street, but it is subordinate to the triplex that is in the front of the house. And the other garden suite that's on its way of being built is being built as of right, and right now there's only footings. So it wasn't really a sort of a good example to be showing in this venue today. So planning staff have documented the same concerns, and I must sort of emphasize that the report that they issued was an information report. They did not express a position. They just went in for the facts that that there's been a variance triggered by the fact that The occupants of 16 James have been living in 2 finished stories, and now now in going to the garden suites, they're experiencing a significant reduction in living space, and they have concerns about being able to make this a forever home. So planning staff have documented these concerns, and by asking to accept the report and without a recommendation, they are definitely leaving it in this committee's hands on what the decision should be. So just to be clear about what our objections are, it is the technical variance about this being bigger than a garden suite. In this case, we've got owners that are looking to expand on their property. However, you do not necessarily get the same considerations from every landowner in the neighborhood. So you must remember to think that how would an investor do it? So they would end up upgrading the home, not adding second stories, and then they would use this particular variance, should it be approved, as a loophole to make it bigger than the main home. So that is sort of the basis of our recommendation. And barring any questions from the panel, I'll leave it in your hands.
Thank you, Ms. Mercado. Any panel questions? No? Okay. Do we have Alexander Donald on the line?
Yes, Mr. Chair.
Mr. Donald?
Mr. Chair, Alexander has asked to be on video, so I'm going to go ahead and make him a panelist right now. Alexander, you're now a panelist, so if you'd like to start and stop your video, you can do so by clicking the Start Video button. I'll go ahead and unmute you at this time.
Okay, I'm not sure if start video, okay.
We can hear you.
I think that's...
I can see him. I'm going to drag him onto the stage right now, and we'll be good to go. All right, Mr. Chair.
Okay, welcome.
Hey, my name is Sandy Donald. I'm from 3436th Street, which is just one street over. I guess I sort of did submit stuff. As people are probably well aware of, Long Branch is very, very sensitive to the whole idea of lot splitting and that whole approach. The biggest concern, or really the main concern I have with this, is garden suites are new. So really any decision in regards to garden suites outside of the existing bylaws becomes precedent setting. And very definitely the idea of 48% off the bylaw, that's not minor at all. And the concern is this can be used elsewhere to justify basically garden suites that effectively become really houses in their own right. Unfortunately, the way that decisions are given from the Committee of Adjustments, it's either, no, it doesn't meet the 4 conditions, or it does. Well, in this case in particular, if the decision is it meets the 4 conditions, that's it. This can and will be used as precedent going forward. I'm very well aware of the situation where, and if they have a smaller house on the lot, or the main house is smaller than normal, or it's definitely below the 0.35. If the committee decided in favor of this, I would recommend very, very strongly that it's not normal, but in the decision, one actually gives the reasons why, so that this cannot be used as a precedent that, say the house is 0.35, then, well, on the garden suite, we can go 48% larger than what's allowed. As I said, the big concern is this can be used and will be used as a precedent to have, or to build, and for lack of a better word, monster garden suites and whatnot. I don't think that's the intent of this application, but that is how it will be interpreted. So if it was approved, I would recommend very strongly, which I believe you are allowed to, in the actual, not just saying that it meets the 4 conditions, but also saying why this is the exception. And this does, it's a corner lot, everything like that. They're talking of the base, the sort of the original dwelling and whatnot is quite a bit smaller than what's allowed. So as I said, the biggest concern is this can be used as a precedent, and very definitely 48% off the bylaw. That is not minor. And as I said, if it's applied to larger houses, we're going to quite literally end up with monster garden suites, which I do not believe that's the intent of garden suites, and that's not the intent of the official plan. That's basically my comments.
Thank you, sir. Any questions from panel members? Seeing none, I thank you for your presentation, and we'll move on to the next one. Paul Blundy, is Mr. Blundy on the line?
Mr. Chair, Paul is, but he also would like to be on video. So if you bear with me while I take Sandy off.
You're double tasking there.
Yeah, it's all right though. Paul, I've bumped you to be a panelist, so you're now able to turn and turn off your video as you see fit. I'll go ahead and unmute you as well. We've also got member Gully straightened out, so we'll re-add him to the meeting. And I see you now, Paul, as well, so I'll update that. And you are unmuted, so whenever you'd like to start, please go ahead.
Okay, thank you very much for your assistance. I'm the owner of a house at 23 James Street, which is basically across the street and on the other, across James Street and across 37th Street from the subject property. I see this timer is counting down to 27 seconds. I think I have to talk quickly.
Mr. Chair, we'll get the timer.
We'll get you reset.
Yeah.
Okay, no problem. I only want to appear just to speak in favor of the application. I think that the variant is extremely minor and to deal with an oversight in the drafting of the legislation, the structuring, the counting the floor space of the crawl space seems to be ridiculous. I think it should go ahead. I think it's consistent with the intensification of the neighborhood. The neighborhood is a transit node location. Intensification is the way of the future, and I'm all in favor of the proposal. Having said that, I liked the point that Sandy Donald, the previous speaker, made about putting something in the decision to indicate that it is clearly exceptional on the basis of the fact that the overage in the coverage is, or the gross square footage is based on a crawl space and not on actual living space. I think that would be a useful thing to put on there and would address Sandy Donald's position about making sure this isn't precedent for monster garden suites. But garden suites generally are consistent with policy and are a really good land use and lead to a nice gradual and progressive intensification of the density in the neighborhood. So I'm all in favor.
Thank you, sir. I'm assuming there are no questions. Thank you. Is there anyone else to speak on this item?
Mr. Chair, that was all the area residents that are interested in speaking.
Okay, perhaps we can have the agent come back.
Yes, Mr. Chair. As a reminder, they're interested in being on video, so I'm going to go ahead and remove Paul, and then.
Is there anyone else in the room for 16 James? Okay.
All right, Mr. Chair, bear with me. I've removed Paul, and I'll go put Daniel on the panelist list. Daniel, you're now on the panelist list, so feel free to activate your camera. I see you now, so I'll bring you over to the stage, and we can and you'll be able to speak with your 5-minute rebuttal. All right, Mr. Chair, Daniel is on the line, and he is unmuted. So,
okay, Daniel, welcome back. Can't hear.
Sorry, do we have audio now?
Yep.
We do.
Yes, thank you, Mr. Chair. Through you, I will speak to some of the concerns raised by the neighbors. In the order they presented them, the neighbor at 14 James Street, Richard Eastwood. I should note my client texted me to say that they rebuffed his approaches to speak with him ahead of the hearing. So he did try, but he raises concern about the crawl space being used as habitable space in a basement. And with all due respect, it can't be. It has no windows. The main floor is at grade, which is pretty much a requirement if you only have 6 meters of height to make garden suites work. Your main level ends up at grade. This is also what investors do. We work with them. They do not build basements or crawl spaces. They are far too expensive. They build slab on grade. I'm assuming Mr. Eastwood's home has a traditional raised main floor, basement windows underneath, and the 6'5" or whatever he has of headroom is actually adequate. That is clearly not the case here. This is not a basement. It is not a basement under the building code. It is needed to house the mechanical equipment though, because we are not simply putting in a gas boiler. This is a zero carbon home. This is powered by air source heat pumps, and it's a ducted air system, and it actually requires a fairly large piece of mechanical equipment suspended sideways in the crawl space, ducting to run around as well. So it's not a little wall-mounted gas boiler, because we are trying to decarbonize houses as we go and not leave things to be retrofitted afterwards as we try to move the city towards the council stated 2040 goal to have a net zero Toronto. So it does actually need the space. And then, of course, there is storage space. Absolutely. When downsized, storage space is appropriate. As Ms. Mercado mentioned, basements are permitted. There isn't the question of this. The question seems to revolve around one of setting a precedent, which is speculative, but I will not speculate on what this committee or future committees will make of precedents. But I will comment that the planning department was instructed by Planning and Housing Committee to report back after 2 years or 200 applications with recommendations for tweaks to the bylaw. They did so with laneway suites. In fact, they reduced some setbacks, they added extra height, they modified soft landscaping requirements, as I'm sure you are well aware after that review. David Dreger, the lead planner on the file, we know fairly well. He actually engaged with our firm to do extensive consultation leading up to the garden suite bylaw on how we could remove impediments to making zero carbon buildings. One of those is, in fact, counting interior floor area, not exterior, so you don't penalize people who build extra thick wall assemblies as we propose. We do wall assemblies above code minimum, aka the worst thing you're allowed to build. We build thicker walls, typically 9 to 12 inches. If you don't have this interior floor area count, you penalize people who wish to go greener with their home construction. And Rick and Monica are extremely green focused. So there is a reason why it's interior floor area. As David noted to me when we communicated with him extensively around this crawl space issue, he said that was a bit of an oversight. They hadn't figured that the definition is not a fair comparison. If, as I pointed out, you make it a fair comparison, you either include the basement of the main house in your calculation or you exclude it from the garden suite. We are fully compliant with the intent of the bylaw, which is, I agree, to have garden suites that are subordinate to the main houses, even with the small bungalow that's on the site today. I believe that has addressed everything people raised. Otherwise, I could note about the shed, I suppose, that Mr. Eastwood mentioned. To be clear, the shed was moved once it became apparent that it would not trigger any minor variances and not need permission to be moved. It is there legally as of right. Returning down these variances won't change the impact. It is fully compliant, as is the height and any shadow effect of the proposed garden suite, fully compliant with what council envisioned people would be allowed to build on a property like this. I don't believe that a shed with a closed wall causes harm to privacy. I get it. Nobody wants to have a blank wall beside them, but this particular neighbor has a shed on his property up against his other neighbor's property as well, and so on and so on. This is what we do in our backyards. So I'm not sure there's much that could be gained by refusing the minor variance to benefit Mr. Eastwood's sun, shading, privacy concern in his backyard. The tree he did raise, our last point, we had extensive work with a very qualified arborist, Wendell Lee of Elite Tree Care, former City of Toronto urban forestry employee. They did air spading to expose the roots in a non-invasive way, for those of you who are familiar with this. And the plan in her report shows quite clearly we can get drains and water line right up against the foundation wall of the house that will not cause harm to structural roots of the tree. So we take it very seriously. We're firm committed to green design, and trees are a big part of that. Thank you.
Thank you, Mr. Hull. Before I turn it over for questions, I have one question myself. I'm just noticing on a map, we haven't heard anything from the owners at number 49 37th Street. Just wondering if they were approached, or if you could enlighten us on that, because they would be the ones that are right next to where the garden suite's going.
Yes, Mr. Chair, I believe number 49, Alex Wilkinson, is a signatory to one of the 3 petitions of support, 49 37th Street. I actually checked that this morning.
Perfect, thank you. Members, any questions of the applicant? And if there are none, then let's take it into committee for discussion. And just a question to Secretary Treasurer, ma'am. Ms. Bartosik, can we actually add some, I know that it's the longer stated goal that we actually do create more reasoning in our decisions. Is that something that's premature at this point, or can we add that?
You can, you would just have to give me specific
Okay.
wording for us to include.
Okay, thank you. Mr. Taylor?
Yeah, thanks, Mr. Chair. Yeah, I'll just kick this off with a couple of comments. One that I was strongly influenced by was the commentary in the community planning report about the as-of-right zoning, which would allow 220 meters squared on this lot. So I've been thinking about the appropriateness of what's proposed here relative to what is permitted as of right. And I'm satisfied that this very small house with an admittedly larger garden suite meets the overall intent of the bylaw in terms of the massing that is permitted as of right on the lot. Heard some comments about trees. We have our experts in urban forestry have requested their condition number 2, which will hopefully address those concerns. No other agency comments or objections. So I'm positively inclined on this one. That's a comment for now.
So, thank you. Anyone else? Anyone ready for a motion?
Chair, I was also going to make a comment. I think Mr. Hall did an amazing, persuasive argument for the proposal, the design, and the justification. But notwithstanding that, I still have concerns with respect to the fact that the garden suite will be larger than the principal structure on the property. And in most instances, not in most instances, I always respect the professional comments made by our professional planning staff on these issues. But I'm not totally convinced that looking at the total permitted GFA is the way to go on this one. I think as far as garden suites are concerned, they're certainly desirable, they're appropriate. That's the way to go in the city of Toronto if we want to get single-family homes and low-density additional units in our low-density areas. But in this case, in this specific lot, at this specific geographic location, I'm not convinced that it's the right thing to do. I've looked at the 2 variances that are being requested. I have some concerns with respect to the parking. I have some concerns primarily with respect to the rationalization of the GFA. So I'm going to move that the application be refused.
Is there a seconder for Mr. Gully's motion? Seeing none, I'm going to declare the motion failed. I don't think I can second because I don't want to get into a tie situation. Is there anyone looking to do an alternate motion?
I'm inclined to approve this application. I too was convinced by the submission of the applicant, and I would particularly want to note as well that I do see this as an exceptional case with respect to the comments made with respect to the crawl that the so-called basement is in fact a crawl space, and the plans there to actually make it a green home. And so for those considerations, I would move that this application be approved, and that exception be specifically noted in the decision.
I need the specific wording that you want as a reason.
You've got a few options.
Yeah.
The main house is less than the maximum permitted square footage is one. The other is that the crawl space, but the crawl space is part of the bylaw, so that's not really, I mean, that's the way it's defined. We could also suggest that because it's a corner lot, it creates a bit of a different situation. I think that was a suggestion by Mr. Donald. Are you good with both of those?
I'm good with both of those additions. Thanks, Grant. Can you just help in that?
So, yeah, so given that in this exceptional situation, the existing main house is considerably less than the maximum permitted coverage, and that this site is located on a corner lot.
Yes, it's forestry condition 2. Thank you, Mr. Chair, for articulating
No worries.
the motion I was trying to convey.
I still need a seconder.
Mr. Chair, I'll second the motion just with a comment that I guess goes along with additional reasons in my mind. I think it's very significant that this proposal does not require any other adjustments or variances with respect to rear yard, side yard, separation distance between the garden suite and the main dwelling, and height. So I think generally it's quite in keeping with the zoning requirements for garden suites in that respect as well.
I think it's just a commentary.
A commentary or agreed upon by.
Yeah. All in favor? Opposed? And I'm going to refrain.
So we have a motion to approve with, other than the 4 test reasons, that the corner lot is a unique situation and it's an exceptional situation as the existing main house is less than the permitted, was it floor space index or coverage? Okay, thank you.
Floor space index.
Thank you.
Okay, so that's approved. I abstained. Thank you. Because I can't create a tie as a chair. I can't create a tie. If I were to vote against it, it would be a tie, and I'm not allowed to do that as chair. Given that we've gone quite a bit over time, I'm just wondering what would be an appropriate time for another break, whether we do one more item or break now? Okay, 5-minute break, please.
Thank you, Mr. Chair. We'll come back at 12:30. It's 12:25 right now.
Want a lunch?
Or do you want to do can we do a lunch break?
Yeah.
Sure. I mean, well, how does it, I leave it to the panel members.
How long would you like to break for?
Yes, although you're going to take a bit of a risk as to, in case some of our items go quicker than you may think. Usually we don't take this long on every item.
You can join virtually or through telephone if you'd like.
Yes, absolutely. We have to finish today. We may, even if we're here till 7 o'clock, we have to finish today.
So what's the time, Mr. Chair? Half an hour?
Okay, so be it. Let's just break for lunch now, and we'll be back at 1:30. Does that work?
Thank you, Mr. Chair.
Okay, thanks.
Hey Adam, do you watch the deck? Who did this? This is like a dope looking, as opposed to like right in your face. I like that. That's dope. Yeah, I like that. Do you know who made this popular? This move? Trump. At all when he did it? And you know why? Because this was blocking the face. So it's all getting higher. Yep. To get more control. Yeah. Well, because naturally people do that anyway. So they just kind of do a lean.
Hoping it's not going to be a third.
Overtime. Double overtime.
Good afternoon, everybody. My name is Adam Wills, application technician with the Community Adjustment Etobicoke and York. Thank you for bearing with us while we took our lunch. We will get started here now that it's 1:30. We'll look to get started here in a moment. And once we get the members' cameras turned on and whatnot, we'll look to get started.
You got to do it with the mouse.
All right, Mr. Chair, we've got all our members ready to rock. So whenever you're ready to start, we can.
Okay, thank you, Adam. Good afternoon, everyone. Welcome back. We're starting up at item number 6, which is 257 Dunraven Drive. This is an application to construct a laneway suite above an existing detached garage in the rear yard. There are 4 variances, 2 of which have been revised. Planning is requesting a condition of approval, and that's all we have. And the speaker is Marco Vieira. Welcome back, Mr. Vieira.
Mr. Chair, as a quick reminder, there is an area resident on the call for this item.
Okay, thank you.
They are virtual too. All right, Marco, you're unmuted, so go ahead.
Good afternoon, Mr. Chair, members of the committee. Marco Vieira. I'm the agent and the owner of the property. We're at 257 Dunraven Drive, and I can give you a brief presentation if you so desire.
Probably, because we do have another speaker, and I'm not sure if that individual is in support or opposition.
Certainly. Okay, so through you, Mr. Chair, the proposal before you is to construct a new laneway suite, removing the existing frame garage. There will be garage parking at the lower level, and the garden suite, or in this case, the laneway suite, will be on the 2nd story. I did provide some presentation materials to clarify variance number 2 and variance number 3. There was originally an error done by the zoning examiner for our percentages, so that has been revised. And as a result, the variance number 2 and 3 have been increased from 63% to now 67% with regards to variance number 2. And variance number 3 has been increased to 48.16% at 1.118 meters. The Gardens laneway suite is being located essentially in the existing footprint of the frame garage that is there. It is next to an existing concrete block garage to our south and also to the southeast of us. The variance for angular plane only catches approximately 6 to 8 inches of the parapet cap from the existing dwelling to the front, or in this case, the side of the laneway suite. We believe the variances are, in fact, truly minor. We're tried quite extensively to comply with the bylaw where possible. The access is being maintained off of the public lane with essentially complying with the landscaped area as the majority of the lot in the rear is soft landscaped. We believe that the 4 tests are being met, and we ask the Committee of Adjustments to approve the application.
Thank you, Mr. Vieira. We have another deputant, Santiago Costello. Is Mr. Costello on the line?
Mr. Chair, they did originally ask to be on video.
I'm online. Hello.
During the
Good
microphone
afternoon.
check, we confirmed that Santiago would just be fine on video or audio only. So Santiago, go ahead.
Yes, good afternoon. Thank you very much. I don't oppose to the project. I'm the owner of 1655 Keel Street, which is directly behind the garage. I mean, my garage is exactly in front across the laneway from where the construction is going to be happening. So I don't oppose the project at all. I'm fine with it. Me and my wife are okay with it. My only concern, if I may ask this question here, is if we're going to have any trouble or problem accessing our garage during the construction, because it's a small laneway. So that's my concern. That's what I wanted to be in this meeting. Yeah, that's the only question I have. Is we're going to have any difficulties accessing our garage during the construction period. That's it. Yeah.
Okay, thank you for your presentation. Thank you for expressing your support. And I think Marco can address your concern. Mr. Vieira?
Through you, Mr. Chair, I don't foresee an issue with accessibility. The new laneway suite is being proposed to basically the existing footprint of the existing. So there will be same distance between the proposed garage and the adjacent neighbor, or in this case, the neighbor to directly in front of the entrance door. So I don't foresee an issue there. The neighboring garage also is set back from the lane, and those setbacks aren't going to change. And during construction, we will ensure to maintain, accessibility to his garage.
Thank you. Any questions from panel members? Mr. Taylor?
Yeah, just I believe the caller was more interested in the construction phase. Like you're going to have vehicles and lumber and drywall and shingles and whatever. If I understood Santiago correctly?
Through you, Mr. Chair. No, we have the rest of the backyard to use for material, so we don't anticipate having to encroach into the area in front of the garage. The remaining area of the backyard is now open. I mean, it's got just a trampoline for the kids. So once that gets relocated, we'll have plenty of space to locate materials on our lot.
Okay, thank you. I'm okay if Mr. Castillo's okay.
Okay, anyone else, or can we move to committee?
Mr. Chair, there's nobody else on my list. Maybe if you want to ask the room.
Is there anyone in the room for this item? No. Okay, thank you. We'll take it into committee for discussion and motion.
Chairman, I'm prepared to speak on this item. Again, Chair, we have a report from Toronto City Planning dated October 12th with a condition. I'm sure that the agent is aware of this condition. He hasn't indicated to the effect that he has any concerns regarding it. What we have before us is a laneway suite above an existing rear detached garage in the rear yard. There are 4 variances that are being requested. The 4 variances, in my view, are indeed minor. They're appropriate. Certainly, the approval of these variances is desirable in view of Council's vision and wish to increase residential units within the low-density residential zone in the official plan and the zoning bylaw. Variance number 1 with respect to the width, minor from 8 to 8.71. Similarly, the soft landscaping as well as the landscaping in 3. The changes that have been made since the original submission are substantive.
they are indeed appropriate, and they make the application even better than originally was. I move approval subject to planning's report condition of October 12th.
I'll second that.
All in favor? Okay, unanimous approval. Thank you, Mr. Vieira. Our next item is number 7, which is 1 Westacre Drive. And this is a application to construct a 2-story rear and west side addition. There were a total of 7 variances. There are now 4 variances, all 4 of which have been revised. We have Urban Forestry requesting condition 2, and I think that's it. The speaker is Natalia Gavrato. Is Natalia online?
They are, Mr. Chair, but we didn't get a good microphone check with them earlier in the day. So, Natalia, are you there?
We have someone in the room, I believe, who's representing the application.
Oh. Okay. Please.
I do want to bring to everyone's attention, though, there is a user on the call named Natalia, who is the agent for the file, but if I'm correct, you're the property owner?
Sorry, she's available. I'll rather for her to...
Well, I just tried to... We can try again, though, if you'd like to see, because we just did try her, and there's no response. Natalia, this is a microphone check for Natalia Gavarotti. Garavito. Natalia, are you there? Yeah, Mr. Chair, they are present, but they're not either hearing us or they didn't authorize to use their microphone. So maybe we'll go with Edison here.
Good afternoon, Mr. Chairman and members of the council. My name is Edison Sanger. I'm here to propose a change on...
Can we get your address as well, please?
My address?
Yes.
400 Rustic Road.
Okay, thank you.
I'm just helping my friend. He doesn't speak very well. There's a language barrier. Therefore, I'm interviewing for him, and he doesn't understand much of this technology, this wording. So I'm helping him a little bit.
Okay. I don't think we need a full presentation. I'm assuming there's no one else here for this file.
Okay, I understand.
Okay. So if you just hit us with some highlights, and then if members have any questions.
So basically, this is a corner lot house. It's very old. Okay. What it's planning to do is just to build a new house to align with the existing neighborhood. That is the smallest lot in the street. Therefore, that's why we're requesting the variances to align with the existing neighborhood. There have been similar setbacks accepted for the proposed setback, and the planning city department is in support of this proposed. And we are basically trying to comply with every aspect of the city.
Well, you've made a lot of revisions, so it looks good.
I think we are. I know we have some notes from the forestry, yes. And I don't think we are doing anything with the trees, so that's why I was wondering about that.
You probably have some private trees that they want to make sure you protect.
Okay, we don't have an issue with that.
That's the only condition that we have.
Okay, that's fine.
So any questions from members? Okay, thank you very much. Discussion or motion?
I can make a motion. So I think this is a fairly straightforward application. I commend the applicant for the amendments made to bring the application more in keeping with the 4 tests, and I find that the application meets the 4 tests as revised, and I move for approval subject to forestry condition number 2.
Seconder?
I'll second that motion, Mr. Chair.
Mr. Taylor? Okay, all in favor? Okay, you're approved unanimously. Thank you. Next item, number 8, 150 Brentwood Road North. Let me just get my file. Okay, so this is an application to construct a new detached dwelling with an attached garage. There are 6 variances, 2 of which have been revised. And we have forestry requesting conditions 1 and 2. We have planning requesting a condition of approval. And there are advisory comments from Metrolinx. We have an objection letter, and we have a concern letter. And welcome back, Mr. Addison Mill Price.
Thank you. Good afternoon. Again, Mr. Chair, fellow of committees, Addison Mill Price, planner at Design Plan Services located at 900 the East Mall, Suite 300, here on behalf of the owner. Would the chair and committee like me to go through the change in variances prior to my presentation, or are you satisfied with the revised public notice that's on screen?
I think we're good with that. Is that a result of discussions with planning, or?
Yes, Mr. Chair, that is based on the recommendations that planning staff gave to us.
Okay, there are a number of speakers, so I leave it up to you as to whether you want to do a full presentation or not.
Thank you, Mr. Chair. I will go through a presentation and give some justification for these variances. Before I speak to the variances individually, I'll point out that there are no public agencies or departments that have any objections to this application. And I want to make sure the committee is aware that while the letters from the neighbors were originally titled as letters of support, there were letters of concern or concerns made within them. And so I will address those concerns specifically. Variance 1 for lot coverage corresponds to a difference of about 26 square meters over what is permitted as of right. As the planning staff report points out, 1.5% of this lot coverage is a result of the covered front porch. The planning staff report also points out that the proposed lot coverage is quite similar to recent approvals along Brentwood Road North. For example, 158 Brentwood Road North was approved at 39.3%. 159 Brentwood Road North was approved at 42.33%, and 175 Brentwood Road North was approved at 44%. I can go through other approvals if you'd like, but based on these examples, it's my view that the proposed lot coverage is in keeping with the established physical character of the neighborhood. Now, in terms of the proposed floor space index as amended, in a similar manner to the proposed lot coverage, the FSI is within the range of similar approvals, both on Brentwood Road North and in the broader context. I'll point out as well that this is not an example of a building that has been maxed out as far as the zoning bylaw permissions will allow. You'll note that the building length is less than the maximum 17 meters, and this was a result of managing the areas understanding of the existing context, as well as working with planning staff. Now, with regard to variance 3, the front yard setback, this represents a difference of 29 centimeters less than what's permitted as of right, and the variance is not required for the entire length of the front main wall. Importantly, the portion of the dwelling that will be closest to the street will be in line with the garage and bay window of the adjacent dwelling at 148 Brentwood Road North, and you can see that on the site plan. With respect to variance 4, the side yard setbacks, I'll point out that the requirements for side yard setbacks on this property is based on the minimum lot frontage required, and in this case, the minimum lot frontage of 13.5 meters is less than the actual frontage of the property at 12.19 meters. As a result, the required side yard setback of 1.2, which would normally require 17% of the lot being devoted to the side yard setbacks, is maintained in proportion through what is before you now. On a 12-meter lot with 0.9 meter setbacks, only 15% of the lot is devoted to side yard setbacks, which is generally in line with that ratio required by the original zoning bylaw. In addition, the proposed side yard setbacks are similar to what is existing on both sides of the proposal. Notably, the final build will be very similar to the setbacks of 152 and 148, both of which do not comply with the 1.2 side yard setback requirement. I'll also note that this proposal will be improving the setback condition on the north that is currently has a pitch point of 0.5 meters and a wall for the main parts as 0.7. With respect to the variance for height, I'll note that the height of 11 meters that is requested is only applicable for a very small portion of the dwelling. As demonstrated on the elevation plans, due to the step backs of the third story, the height proposed will have a mitigated impact on adjacent dwellings. These step backs are on all sides of the building, and therefore the proposed dwelling's height will not have an impact further than what is already contemplated by the bylaw. You can view the approximate as-of-right permissions for height by looking at the second line down from the top of the third story. Now, I'll lastly just touch on the sixth variance, which is more of a technical variance. As shown on the roof plan and as illustrated by the elevations, the proposed dwelling will be perceived as a slope-roof dwelling, and the only portion of the building that's triggering this variance is a small flat portion above the north and south third-story windows. The main wall height for the vast majority of the building, including all front, rear walls, and most of the side walls, is compliant with the exterior main wall height requirements.
Thank you, sir. We have some speakers on the line, I'm assuming. There's no one in person here? No. Okay, so we have some speakers on the line to speak to this item. Is it Ian Hannon and Janice Wilcox?
Mr. Chair, it was Janice who intends to speak. They also asked to be on video, so I'm going to go ahead and make them a panelist now.
Okay.
Janice, you are a panelist now, so I'm going to go ahead and unmute you, and you can start your video if you'd like.
Hey, we're together. It's Ian. I'll choose to speak for us if that's okay.
Okay, that's fine. But do you want to be on video though then, still?
Doesn't matter.
It doesn't matter, actually. We have nothing to share, so it's fine. We can just be audio.
Okay. Give me one moment then while I put you back to a quote-unquote attendee. Okay, Mr. Chair, we're good to go now.
Okay, welcome. If we can just get your address as well for the record.
Sure. My name's Ian Heinen. I'm here with my wife, Janice Wilcox, from 148 Brentwood Road North in Etobicoke.
Thank you. So you're right next door?
Right next door, correct.
Okay, perfect. Please go ahead.
Okay. Thank you for hearing us today. We're looking forward eventually to welcoming our new neighbors. We did review the drawings as revised because we understood there were some revisions. And we have spoken separately to the owner, David Violetta, to express some concerns. We are foundationally, we're concerned that this is an excessively large house for the property. It's driving variances in every dimension, both the front setback, the rear, the sides, and the height. And it will have an impact in terms of the crowding and sort of the lot coverage in the neighborhood. We, fundamentally our concerns is that the house will overly crowd the lot, sets a precedent that would change the character of the neighborhood. I know there's some other houses that have been approved further to the proponent's argument earlier, but this is really a significant construction right next to us that's really very large for the size of the lot. We're going to be visually impacted by the depth of the construction. It's deeper than other properties in the area, and it's driving coverage and setback variances with the depth of the house. In addition, the side setbacks are only 90 centimeters, again, significantly crowding and just large for the lot. We have some concerns about fire separation, and really we think that this 90 centimeters could be easily mitigated, and there doesn't seem to be much of an attempt to try to mitigate that at all. Finally, the height variance and the third floor are a concern for us, and this really does have an impact on us. We have a backyard we enjoy very much. You know, this height variance is exceeding the bylaw by 1.5 meters. Third floor developments aren't really consistent, and we haven't seen them in the neighborhood at all, specifically on Brentwood Road. Again, this feeling of excessive crowding and a lot of house on a small lot. And finally, privacy. This is the big one for us because there's a balcony that is included in the design that will overlook our backyard. And, you know, with the depth of the property combined with the height, as we're sitting in our backyard, we're going to be very much losing our privacy from the proposed development. Overall, the house proposed, we feel, is just too big for the lot. David and Natalie, frankly, seem like reasonable people. We've had a good conversation with them. We'd be willing to work with them, with neighbors. We think we can, based on our conversation. But we're really asking the committee today to deny the request and defer any approvals until adjustments are made that can really address the concerns that we have around the size of the property and the loss of our privacy in the backyard, and afford us some time to actually work directly with the owners. They seem willing to do it as well. That's really all we had.
Okay, thank you. Any questions from the panel members of the deputant? No? Okay, thank you very much. Is Barbara Kirby on the line as well?
Mr. Chair and members, Barbara is not on the line. We did go and reach out to them as well via email and phone call, and we did get a response back saying they were going to try and attend, but they have not joined.
Okay, Lori Infusino?
Yes, Mr. Chair, Lori is present.
Perhaps we can hear from her then.
Lori, you're unmuted.
Thank you. Thank you to the committee. And we're just the neighbors directly north of the property and wanted to take an opportunity to share our concerns with the proposed variances. The proposed build size largely exceeds the bylaw with respect to lot coverage, and particularly we have concerns with how far back the new dwelling will extend into the backyard and the possible impact it may have on our enjoyment of the property, of our property. And we really appreciate the owner's desire to build a larger home. However, we hope that some of the variances can be revisited or adjusted to come more in line with the bylaws.
Okay, sorry, are you to the south or to the north?
To the north.
The north, okay. Thanks, thank you. Members, any questions? Thank you for your presentation. Is there anyone else on the line or in the, I'm assuming there's no one in the room.
No one else on virtually, Mr. Chair.
And have we found Barbara Kirby or still not there?
Still did not show up in the end.
Okay, so maybe if we can get Mr. Milne Price back for a rebuttal.
Thank you, Mr. Chair. And thank you to the neighbors for their submissions as well. Now, the first thing that I'll note is that the main concern from both abutting neighbors is largely a result of how far the proposed dwelling goes from the existing dwelling and both of the dwellings on either side. I'll point out again that there is no variance for rear yard setback for building length or building depth. Of course, a compliant building could be built as far back as 3 meters farther than what is proposed. I think it's also worth noting with regard to the concerns that the neighbors had in terms of overdevelopment, that the proposed house has no variances for soft landscaping or landscaping itself. It's compliant with those requirements as well. In terms of the side yard setback and how that relates to any concerns from fire separation, I'll just note that, as I stated, this is an improvement of the side yard setback on that north side. Right now it is 70 centimeters, and it will be 90 centimeters in the proposed version. As far as I'm aware, there are no current safety issues on this existing dwelling, and the proposed would just improve that situation. In fact, if you look at the site plan,
Sorry, can you also address the other, I won't interrupt your time, I'll ask after, go ahead.
absolutely. You'll note that if you look at the existing walls versus where their proposed walls are, the proportion of setback is largely staying the same. The proposed house is mainly just shifting slightly to the south to even out the side yard setbacks on both sides. The neighbors also brought up concern relating to height, privacy, and overlook. I'll note that while there is a variance for height, there is no variance for the amount of stories. 3-story buildings do exist on 150 Brentwood, on Brentwood Road North and within the broader neighborhood. And there was also no variance required for the balcony. The interaction between the proposed building depth, the balcony, and the height is largely already contemplated by the zoning bylaw. Now, in terms of the front yard setback, I'll note as well that the proposed main wall is in line with the building to the north, as in terms of its bay window and in terms of the garage. This can be seen on the site plan, and therefore, my opinion, you will not be able to perceive any significant difference in terms of distance to the street on the proposed versus the existing. I believe that it addresses the main concerns, but I'll point out as well in terms of the height variance that it is only a small portion of the building that requires that 11-meter variance.
Thank you. You've answered the question I was going to ask, so I'm good. Do the panel members have any questions for the applicant? Mr. Taylor.
Yes, Mr. Milne Pierce, could you, Price, keep calling you Pierce. Mr. Milne Price, could you tell us, please, what the existing south yard setback is?
The existing south yard setback from my memory is 1.21 meters on the rear side and 1.24 meters on the front.
Okay, thank you.
Any other questions? We can take it into committee then. Any discussion? Or is someone ready for a motion? Just keeping in mind that there's planning has a requested condition of approval and there's 2 forestry conditions.
Mr. Chair, I'm prepared to table a motion. Generally, I find the building proposed here fits within the building envelope set in the zoning bylaw. I accept Mr. Milne Price's evidence about the improved north side yard setback. I'm impressed with the fact that there are no landscaping variances required. There is no rear yard setback required, and that the height variances are related to a very small segment of the roof. So I'm satisfied that the application meets the 4 tests under the Planning Act, and I move approval subject to urban forestry conditions 1 and 2, and the community planning condition tying approval to the site plan as it relates to lot coverage.
Do we have a seconder?
Chair, I'm prepared to second that very comprehensive motion. The only thing I'll add is, of course, relating to the issue that was raised by some of the residents, There is no variance with respect to building length or building depth, which makes it even better. As far as the side yards are concerned, the building is balanced on the lot. So I second it with those motions, with those conditions, Chair.
Okay, all in favor? Okay, let's carry unanimously. Thank you, sir. I need a microphone. Our next item, number 9, is 27 Mattis Road. And this is an application to construct a new detached dwelling with a detached garage in the rear yard and a second-story garden suite above the proposed detached garage. It's kind of a theme for today, garden suites. The original application had 11 variances, and 2 have been eliminated, and 7 of the remaining 9 have been reduced. Forestry is requesting denial, but they also have an alternative, and planning is requesting a condition of approval. We also have 3 letters of support on file. And our speaker is Daniel Rossetti.
Good afternoon, Mr. Chair and fellow committee members. I am Daniel Rossetti. I'm the applicant owner of 27 Mattice Road. I'm happy to give you a presentation if you desire. At minimum, I would like to address Urban Forestry's comments.
Absolutely. I don't think we need a full presentation. Would like if you could address the forestry comments, and then if members have any questions for you.
Sure. If we could please pull up the development impact assessment, our burst report as well. I'd like to point to some of the pictures in that file. On behalf of my family, first off, I'd like to thank the Committee of Adjustment and Planning for their cooperation and assistance to date, as well as providing us the opportunity to consider the minor variances as presented to construct our proposed family dwelling located at 27 Mattice Road, which will allow us to not only stay in place, but grow in place. We did work collaboratively with planning, so we thank them. Through our consultation, we did reduce the variances from 11 to 9, as well as improved numerous other variances to align with recent approvals on the neighborhood, which I'm happy to touch on if you'd like. In regards to Urban Forestry's report dated October the 12th, we noted discrepancies of concern which do not align with our development impact assessment prepared by our arborist and submitted with our proposal. We've since had detailed discussions with our arborist and had a second opinion from a third arborist who contacted Urban Forestry, and they did have a conversation. We feel it's prudent that the committee be made aware of these discrepancies in forming the decision. The arborist was confident that they could come to solution with Urban Forestry. The first discrepancy was that Urban Forestry makes note of us removing our healthy bylaw protected tree number 9. That's the Norway maple in our front yard. We are not actually removing that tree. We are protecting it with a TPZ barrier. We do like the tree. I do want to just point out, though, however, it is not completely healthy in nature, as it's had white fungi all summer and lost its leaf. We're asking permissions to prune it with a slight injury. And then in regards to variance 9, Urban Forestry reports us removing trees 1 to 7. That is correct. However, it's prudent that the committee be made aware that these trees in question are actually white spruce, as noted in the DIA, and the majority are not in good condition, either being noted as fair or fair/poor condition. In discussion with our neighbors, these trees were planted by error by a previous homeowner on city property. You'll notice that they're coniferous trees. Those are not typical trees planted by the city on boulevards, and their low-hanging branches often create sightline problems either out of our driveway or others. Also, these trees have been dangerously falling because they're skinny and tall. In the storms, either high wind or snow, they dangerously have been falling. I have 2 young children that often play in the backyard, and there's many neighbors walking their dogs along the fence line. Last March, 3 of the trees fell dangerously. I woke up at about 1 a.m. in the morning to cracking, and you'll see in the pictures in the DIA, I've got some additional here. It was quite dangerous. So we feel that our proposal in regards to the trees is positive in nature. For one, it removes a major safety issue. The trees will be removed at us by our cost in lieu of the city having to remove them at their cost. We will pay the permit fees and or cash in lieu to remove these trees, and in our due diligence, we'll do our best to plant additional trees on our property. Just in conclusion, our goal with this application is to raise our family in this neighborhood. It's a great neighborhood. It makes us feel safe with great neighbors. We take a lot of pride living in this neighborhood. And without the support of committee, this may not be feasible to stay in the city of Toronto and specifically this neighborhood. So we appreciate your time. Thank you.
Thank you, sir. Thank you for being ahead of time, too.
Yeah.
Members, any questions? I'm assuming there's no one here for this item. No one else? No?
And nobody on the virtual, Mr. Chair.
Okay, thank you. Any questions for the applicant? Mr. Taylor?
Thanks, Mr. Chair. Yeah, one question, and it's about urban forestry. You're aware of their October 12th memo to the committee requesting their condition 1 with respect to a city-owned tree?
Correct, yes.
Okay. And you take issue with that, and you would rather us approve it without that condition?
No, I take issue with the denial. We will work through with urban forestry to get approval to remove these trees.
So
Yes.
condition 1 would be
Correct,
acceptable
yes.
to you. Thank you.
Yes. We take issue with the complete denial.
Okay, if we can move this to committee, if there's any discussion or if anyone's ready for a motion. So we have urban forestry 1 and planning condition of approval as well. And 3 letters of support, no opposition, just to recap.
Mr. Chair, I'm prepared to make a motion unless either of my colleagues have any questions, comments. Okay, just a quick comment right off the top. I'm really pleased to see the take-up on the city's policy with respect to garden suites and laneway suites. We're seeing quite a healthy volume of activity in those areas, and I think they do a lot to address the obvious issues that gave rise to them, which our applicant today alluded to. Keeps people in these neighborhoods. It's a wonderful thing. With respect to the application before us, I'm satisfied that the, and I'm referring to the revised agenda page, so I believe we have 9 variances. I'm satisfied that they all meet the 4 tests under the Planning Act, and I move approval subject to urban forestry condition 1 and the community planning condition to construct as illustrated on the site plan as it relates to lot coverage.
Okay, do we have a seconder for Mr. Taylor's motion?
I'll second.
All in favor? Okay, you have unanimous approval. Thank you.
Thank you very much.
Okay, our next item is number 10, which is 96 Black Creek Boulevard. And let me just find that. Oh, I already have it, sorry. So this is an application to construct a new detached dwelling with an attached garage. There were 7 variances that were being requested. 1 has been eliminated and 2 have been reduced. Urban Forestry, again, was requesting denial initially, but I think they have an alternate of condition 1. Planning has conditions of approval, and transportation has conditions of approval. And Jonathan Bentkovsky.
Good afternoon, committee. Welcome back, Mr. Gully.
Sorry, is there anyone else?
Mr. Chair, there is an area resident in chambers that will speak to this.
Okay. Okay, Mr. Bentkovsky, given that there is someone here, would you like to do a presentation or just give us a brief summary?
A little bit of both, Mr. Chair. If you would like me to review the changes, I did submit a waiver of what we have altered. And again, it is on the screen there. And again, I would ask that any approval today, if meritorious, be tied to these revised variances. We did work with planning on a couple of things in order to have that staff report that does not have an objection, but rather really tying it to the plans. If we could go to the support material I filed, there's a couple of things I'd just like to quickly highlight. In terms of the urban forestry report, this is somewhat of a unique site in that it's a corner property that has a very, very large boulevard along the corner. And what that does is a couple of things. One, the front yard setback variance we're requesting is actually for just a pinch point. If we could see it where I have variance for the front yard setback there, it's just for that pinch point at that portion there. What I've also done is I've made a green area the entirety of that city boulevard. So again, being a corner property, the variance requested does not relate to the proximity of it to the adjacent dwelling. It's actually to that pinch point on the corner there. The dwelling itself is in compliance with the zoning bylaw and is actually in excess of the zoning bylaw for the front yard setback. In terms of how that deals with forestry, this is really, for a lack of a better term, damned if you do, damned if you don't. In order to build any new dwelling here with a relocated driveway, either along the Woodgate side or the Black Creek Boulevard side, there would be a removal of a city tree. We chose the Black Creek side because there is only now one tree to be removed due to a relocated drive aisle. Along the Woodgate side, it is also heavily treed as well as brushed. And also the uniqueness of this lot, where it narrows and tapers to the rear, also isn't conducive to a detached garage or to bringing the vehicle into the side wall of the house as it faces Woodgate. As I spoke about, we actually do have a 7-meter front yard setback to the actual dwelling itself. In terms of the building length and the building depth variance that is before you today, the dwelling itself is 17 meters. Because we have a small covered rear deck at the rear, that does not span the full width of the dwelling. That is included in the building length as well as the building depth. It is my belief that we do not need the building depth variance, but out of an abundance of caution, I would like to leave it. But again, if you were to tie the approval to the submitted and revised site plan, it would tie us to that. I didn't have time to get a revised zoning review after we spoke with planning, but again, I do not believe we need the building depth because we physically shortened the building to make the dwelling itself in compliance with the 17-meter building length. Again, we've dealt with forestry. I've spoken with planning. They're okay with it. We're okay with all of the conditions of all 3 city departments, and I'd be interested to hear what the neighbor has to say.
Okay, thank you, Mr. Vinkowski. Is it the neighbors here in person? Good day, sir. Please come up. Please introduce yourself and give us your address.
I believe. Thank you, Mr. Chair.
The lights on all the time, so it's confusing.
My name is Dan Rothney. I live at 694 Black Creek Boulevard. If you see in the picture the house that looks like it's almost on the line with 96, that's my house and that's my wall. There is no fence along between my house and their backyard. There was a pool there for many years. It's now been removed. But because of that pool, the fence just cut at my house. My concern relates to 3 of the variances. I'm not sure if this is somewhat adjusted. It did not sound like it. In the interest of time, item 5, there is a 0.08 from the east side lot. That would be next to my house where there is no wall. There is only a 1 foot that I own, so they are literally going to be, I think, digging in stairs less than the width of your monitor between my wall and where they will be digging. I have dug out along there years ago when a good neighbor allowed me to do so to get down to the foundation to replace the drainage for the house. And I know it's very sandy soil. It's just behind Smythe Park, which was Connie Smythe's sand pit for many years. So I know that I'm going to have problems if anything is allowed to build that way. In looking at the overall land space, back in 2011, the city did reduce the size of the street, and the area that was shown in green by the representative prior there, showing the building, that shows you how much extra space there is going that way when they moved that was roadway, and that's now all front lawn for them. So I don't quite follow why the small variance is not so small in my way when we're down to a matter of a foot to the wall of my house. The people who currently live there, I do know they were running a business that's replacing roofs, and they keep all their they were keeping all the roofing materials in there, and I would hear it every night when they put the stuff against the wall and when they removed it in the morning for the next job. So I do know how soft that is and how much I will hear. In terms of the trees at the front, now that they're going to move the driveway, as I understand, to Black Creek, there are 2 trees. These were trees all planted by the city back in the late 50s, so they're 70-year-old maples. If they moved the house, or if they proposed something that was different, the driveway could be on 94 Black Creek instead of where it is and go between the 2 trees. But what I don't understand is why a driveway wouldn't be built off of Woodgate, where they currently have a gate in their fence, where they have driven trucks and cars that they were using the backyard as a parking lot for many a good months, and builds the structure for the parking over there. The tree going down, if the forestry is okay with that, I'm surprised, given that they're beautiful, mature trees that go back to the late 1940s, early 1950s. I think that covers the main components. In summary, I just say that I don't think these are small variances when there's such an opportunity. If this house is being completely taken down and a new house is being built, I don't know why there's more encroachment on where there really isn't any room left to be right next to my house. Thank you.
Thank you. Any questions from the panel members? No? Okay, thank you, sir. So back to Mr. Binkowski then.
Yes, I think there's 2 issues. One dealt with the trees and one dealt with the setback. We did remove that variance for the stair well, I don't want to call it an encroachment, but that side stair that would have been within 1 foot of the property line. So that is a variance that has been removed and is reflected in the revised site plan you have. Additionally, the side yard setback of 1.2 meters is as per the zoning bylaw. We are not requesting any type of a reduction or coming any closer to the individual at number 94's dwelling. I 100% agree. They are beautiful trees, but again, along Woodgate, if we go to the overhead picture I put in within my application, you'll see that if the dwelling were also to have the access off of Woodgate, there would also be vegetation that is removed. We chose the Black Creek side again because there's much more land there for us to be able to get in, rather than as the site tapers to the rear, that opportunity within the rear yard would really take up all of the amenity space in the rear yard. If we were to put a detached garage in the backyard, really there would be then no exterior amenity space at all. It is our understanding from our arborist that we are able to save the 1 tree with the relocated driveway going straight now, with it not being on the angle that was originally proposed. And again, I'm not a big fan of corner dwellings with integral garages along that side face where the mass is larger, and we really noticed that, which would be the case along Woodgate. But again, that would also involve the removal of vegetation. So I'm happy with the forestry conditions. I'm happy with planning's comments, and I'm also happy with the transportation comments who don't object to the entrance not coming off of the flanking side.
Okay, thank you, sir. Any questions from panel members? No? Okay, thank you. Then we'll be taking it to committee. Discussion and or motion.
Chair, I'm prepared to speak on this item. Again, I have reviewed the application. I have reviewed the comments and report from city planning as well as transportation services dated October 17th with respect to variance number 7. Indeed, one of the issues that the speaker was concerned with was with respect to the proposed stairs located at 0.08 meters from the east side lot line. That variance has now been eliminated, and variances 1 and 4 have also been amended to reflect more and keep it more in line with what the zoning bylaw performance standards require. Based on the information before us today, I think we have sufficient evidence to move forward and approve the subject variances, authorize the revised variances as presented to us today, with the condition that the proposed development shall be constructed as illustrated on the site plan submitted on October the 13th and held on file by the Committee of Adjustment, as well as, I believe, UFC urban forestry conditions, recommendation number 5. I'm not sure.
Number 5 is a refusal.
Sorry. Could I get the secretary? Was there a comment from?
Forestry condition 1, which is a city tree.
Yeah.
Oh, sorry. Recommendation 1. So subject to transportation planning's report of, city planning's report of October the 16th and urban forestry condition number 1, move that the variances be authorized.
Not the transportation conditions?
There are no transportation conditions.
There are 3
The
conditions.
transportation indicates that they're okay with variance number 7. Actually, they do have 3 conditions that should be applied as well. Madam Chair, thank you. Sorry, Madam Secretary. So let me recap. City planning report of October the 16th, transportation report of October the 7th with respect to 3 conditions, and urban forestry condition number 1. That's my motion, Chair.
Thank you, Mr. Gully. Is there a seconder?
I'll second that motion, Mr. Chair.
Thank you, Mr. Taylor. All in favor? Okay, we have unanimous approval. Thank you. Thank you, Mr. Benkovsky, and thank you to the local neighbor. Okay, item 11, 19 South Kingsley Drive. This is a application, where did I go? No, wrong one. One second. Okay, this is an application to construct a basement addition to connect an existing detached dwelling to an existing detached garage and a proposed deck above the existing garage. There are 2 variances, and we have no conditions from any departments. There is a support petition and an arborist report. And Peggy Chu is the agent on online.
Mr. Chair, Peggy
Good
is present.
afternoon.
They're there.
Good afternoon.
Thank you. Peggy Chu Architect, 124 Merchant Street, Toronto.
Okay. Is there anyone else here to speak to this application? No? Okay. I don't think we need a full presentation, but if you could perhaps summarize for members, and then if we have any questions.
Sure. I just wanted to clarify that the deck on top of the detached garage is existing. You will see that in the photos from the site, and that the variance for the height of that roof deck, we did have a different calculation for established grade. So I did attach that in the file, so that our measurement was closer to 1.64 meters above established grade. The city zoning examiner did have a different number, but nevertheless, it is an existing deck.
Okay, thank you. Is there anything else, or does anyone have any questions? Seeing none, we'll take that into committee. Any comment or anyone ready for a motion?
Chair, prepared to speak on this item as well. I believe that what's being requested here is really something that does conform with the existing community. The connection between the house and the garage conforms and maintains the character of the neighborhood. The variances that are being requested, the first one relates to front yard setback. I believe it's nominal, it's small,
appropriate and necessary in terms of getting this project going. And as far as number 2 is concerned, it is an existing situation. Although we have reports from Transportation Services, there are no conditions from them. Forestry report, no conditions. There are 9 letters of support. Some of this one variance with respect to minimum front yard setback could be related to the fact that the lot is very irregular in shape. Move approval with no conditions.
I'll second that.
Okay, all in favor? Okay, unanimous approval. Thank you.
Thank you very much.
Okay, item 12, 605 Royal York Road. Let me just pull it up. Okay. So this is an application to convert an existing building into a medical office use. There are a total of 4 variances requested. We have planning recommending refusal, or as an alternative, conditions for only 2 years. We have multiple letters of support, including one from the councillor and from the local MPP. There's a parking justification study. Transportation has conditions of approval. And we have a previous committee decision on file, as well as a site-specific bylaw for this site. And the speaker for this item is Dr. South.
Thank you.
And we also have someone else online, I believe.
Mr. Chair, you'll note that is the agent who is available to speak if the owner who is present wasn't able to.
And there's no one else. Okay, perfect.
No one online, at least.
Okay. Is there anyone in the room for this item? No.
Just my team.
Okay, perfect. Thank you. Welcome.
Hello, Mr. Chair and members of the committee. My name is Dr. Hinel Sheth, and I'm representing myself today as the owner of the property at 605 Royal York. I've been a family doctor in Etobicoke for over 13 years. I love my job. In 2014 and 2015, I opened 2 clinics, Citrus Medical is the name, in South Etobicoke to provide comprehensive healthcare solution with many services under one roof. In 2017, my then clinic manager and I purchased this subject property, which already had a small medical clinic and a pharmacy on the first floor. My intent was to expand the medical services beyond what we already had and relocate doctors from the first clinic. I was under the impression that my former business partner was handling all the necessary municipal permits for building improvements and interior changes during our 5 years at this address. I regret that I wasn't more involved earlier in the administration of such things. It wasn't until we ended our business partnership and I consulted with my current architect, who was online, that I learned that the entire building could not be used as a medical office. A 2011 committee decision allowed for a change of use to permit medical office use on the ground floor of the building only. I acted quickly to legalize the building on my own accord, not because of any order or a complaint from a neighbor, which brings me to this day today. Our main goal is to make sure doctors and other healthcare providers can use this building legally and sign long-term leases without disruptions to continue providing care to our community. Our aim is to provide stability for our community's healthcare needs. I'm here today to ask for approval to use the entire building as medical offices, as we've already been doing for the past 5 years. The community strongly supports this. We have strong endorsements from Deputy Mayor Amber Morley, MPP Christine Hogarth, and the Toronto West Ontario Health Team. They all care about our community's well-being and know that the providers at my building make a massive difference to our community. We are facing a massive primary care crisis, and any disruption affects patient care and community health. I could go on and on about all the things that we do. My architect tells me that our application meets the 4 tests for granting minor variances, especially the test of meeting the general intent of the official plan. We have support from Transportation Services based on our parking study from NextTrans Consulting, which demonstrates a parking surplus, along with the TTC stop in front of our building and bike accessibility, etc. We are ready to comply with transportation's recommendations. We are also ready to follow community planning's conditions number 2 and number 3, but we respectfully disagree with the rationale behind condition number 1. Condition number 1 limits the medical office use to just 2 more years. This uncertainty is a significant problem for our community, and it just sets us back to exactly where we are today. We kindly request that this condition not be added if you choose to approve. This building has functioned as a 100% medical office for over 5 years without any community complaints about traffic, noise, or parking. In fact, it has only shown a significant benefit by providing much-needed services. We have served over 60,000 patients in the past 5 years, focusing on providing care to the most vulnerable patients in our community: elderly patients, babies, children, young families, and patients with mental health concerns. Please take note of the multiple letters of support, not only from the politicians, but from our patients and the nearby daycare whose families and staff use our services on a regular basis. Our services have significantly enriched the healthcare of our community. If it wasn't for patient confidentiality, I would have thousands and thousands of signatures supporting our use. So why test it for another 2 more years and then re-examine under future rezoning? This uncertainty could deter our current practitioners from renewing their leases and staying long-term, further contributing to the primary care crisis. This issue is urgent and time-sensitive. Recruiting and retaining doctors is extremely hard. During the COVID pandemic, those 3 years, I lost 10 doctors. They moved away, just like many Toronto residents did. I replaced them and continued to grow. Doctors want to work with my team. I'm hopeful for an approval without condition number 1 from planning to ensure the continuity of our clinic and our services. It has operated seamlessly for 5 years, and prolonging this process could threaten the healthcare providers of our community and the community that depends on them so much. Thank you very much.
Thank you. Thank you for being brief, too. Just a couple of quick questions. The current use has been in place for some time then?
Since June 2018, when we moved in.
Is the basement being used at this point, or is it strictly for storage?
It's being used.
It is being used. And is that use started under a building permit?
The basement, no. So this was done, I just didn't know. I thought it was a medical clinic on the first floor. I didn't really understand, but it was done by my ex-partner.
Okay, so if we were to approve this, I'm assuming you would go to do a legalization through a building permit process?
Yes.
Okay. Before I turn it over to committee members, I just wanted to point out that it was a site-specific bylaw that established this use of a former police station, and that specific bylaw permitted everything excluding medical for some reason. But that's why we are where we are.
Apparently it was a gun shooting range for Toronto police or something.
Well, that's why you don't want medical. Thank you. Members, any questions? Mr. Gully?
Thank you, Chair. Thank you so much for that very good presentation, informative presentation. I was wondering if you read and your team read the planning report, and in their view, a more robust review of the land use should actually be conducted, particularly since it doesn't meet the zoning bylaw. I was wondering if that number in item 1 was to be much larger than that, because I know you said some of the basement is currently being used. So I know that it may cost some monies to fully utilize the basement. But if that item 1 read with a higher year on it for you to prove that this building at full capacity, and I mean with all the offices that you're proposing in the basement and also on the first floor and the second, you were able to prove that it's still working well
And a few years from now, it might even work much better as people start using transit and so on. Would you be more amenable to that condition 1?
No, so I should clarify, the basement is being used. Like what it is now is what it will be. So the past 5 years, whatever traffic, transit use, visits to the office, whatever's been happening is exactly what's going to happen for the future. So I don't understand what another 2 years, 5 years, 7 years is going to prove.
May I ask you, how many doctors are there operating out of this facility today?
My group is over 20 doctors.
And at full capacity then, how many doctors would you have operating out of there, working out of there?
You only asked me about doctors. We have doctors, we have a pharmacy, audiology, foot care, all of that. So how many more doctors do I intend to add? It's hard to find family doctors to come work, so I don't know.
Okay, thank you.
I wanted to add, I think the point is that since I found out, been trying to work with this, I have renewals coming up. I don't want to lose anybody. And if planning wants me to go through these long processes, how long is that going to take? How much money is it going to cost? How much time is it going to take? How many doctors are you prepared to lose? Can you answer that, right? How many doctors are you prepared to lose in the next 2 to 5 years to go through all these processes to know that we're not doing anything bad to the community? In fact, it's the exact opposite. There's nothing that you can change to the exterior of the building. Like, it is what it is. Transportation has no issues with parking. We're so lucky. We have bike lanes, amazing sidewalks connecting us to our neighborhood. The TTC Royal York transit stop right in front of us. We have TTC on Bloor. We have Mimico GO Station to the south. We make up more than 10 to 15% of the doctors in Etobicoke. My team. It's a huge team.
Sure. I did review very carefully the study from NextTrans, and indeed I concur with a lot of their findings. One issue though that came to my mind with respect to the parking all in the rear, and I visited yesterday, as a matter of fact, in preparation for the hearing. I noticed that a lot of those spaces though are assigned just for staff, doctors and staff. So there's really no on-site parking for patients or anybody attending there. And
Patients park there all day long.
They do.
Oh, yes.
On the designated spots.
Everybody.
Yeah,
it's a first come, first serve, honestly.
Okay. And also, just as a sidebar, I didn't notice a handicap parking spot either. Okay, thank you.
We do service a lot of patients with who use strollers, scooters, wheelchairs. We see those patients all the time. Since COVID, we also have virtual care, so we do phone and video visits as well. But we were open for in-person visits every single day of the COVID pandemic, and we saw patients with all sorts of disabilities, you could say.
Mr. Taylor, do you have a question as well?
Yeah. Just a comment, I guess. No, a question. Are you aware, ma'am, that Councillor Morley supports what you're trying to do?
Oh, yes.
However, she also says, and bringing the zoning bylaw in line. So it's a conditional okay from her. Are you aware that she said bringing the zoning in line?
I did read that. And I know her team met with planning as well.
Yeah. I guess I don't even think I'm going to make a motion on this. The difficulty is, and it says it right here, the proposed medical office is not a permitted use in a zone. And that's kind of a significant statement for a planning group like us to deal with. Somebody wants to do something that the bylaw doesn't allow. Minor variances, they want to do something slightly different, but this says it's not permitted. Mr. Chair, if I may, I think you had the site-specific bylaw up on your screen. Is there any way that, well, I'll tell you what I'd like to know.
We do, it is part of the package. Oh, there we go.
Just, can we just have a quick look at the permitted uses? I'm struggling to find something that's similar.
I thought it was a site-specific bylaw that was the problem for the restriction of this use, not that zone in general. And that being an old bylaw, we don't know the intent of that at that time.
So we can only go with the zoning as we understand it right now, and this statement about the medical office not being permitted, it's a CL zone, and the CL zone doesn't permit medical offices,
but it's,
right? That's what we're dealing with.
It's the only building in that zone because it's a standalone. Like it's not like the area is surrounded by residential.
Yeah, I know the
You know the
very
area.
well.
Yeah.
The 2011 decision allowed for the change of use to permit medical offices.
It allowed a particular medical office.
And we don't know how old that bylaw is.
It's pretty
Looks old.
Yeah.
So typically the medical and dental had different restrictions or requirements because they had a higher parking requirement.
ratio.
And that's, I'm guessing, why they were excluded here.
Sure, if I could just add,
Sure.
help on that. I think back in September 2011, what it did allow was dental and the pharmacy. The last application that was made to the Committee of Adjustment. So I think it was specific to dental.
They changed it to medical, but
Not quite sure about that. After what happened 2011, I'm not sure if it was medical. I think planning would have made some comments with respect to that. I'll have some comments to make a little later, see if I can help.
Are there any more questions, or are we ready to take it into committee?
Speak up.
I can't see a thing.
Indeed, it does speak to a medical suite. For some reason, I thought there was something specific with respect to dental. Was that approved without any amendments?
That's where you've got the reference to the basement not to be used.
In the conditions.
Yeah. I'm going to pull up my own copy of it.
One of the previous decision. Yeah. My screen's all wonky.
The following conditions shall be fulfilled. The basement of the subject property shall be used for storage purposes only. The floor area for the pharmacy shall be limited to 35 square meters. Just while we're deliberating, there's a comment I'd like to make as well, and that's, you know, if the main reason, and I suspect the Secretary of Treasurer is correct, that the main reason medical was excluded is because of the parking requirement, yet transportation at this point is not commenting that there's a parking problem.
Mm-hmm.
And often in these sort of cases, they would say, well, they need to do parking in lieu, or you know, tell us where there's alternate parking available. But I don't see that for transportation this time.
We're very lucky where the building is. There's plenty of off-site parking. There's a Green Pea parking 80 meters away. All the awesome transit and bike lanes. So there's just so many options for patients. A lot of our patients walk and bike.
I had a question. So I know you're take issue with the 2-year limit. If we were to consider a limit, what would you consider reasonable in terms of the permitted use?
Sorry, I didn't hear the first part.
Sorry, I'm battling a cold.
I think just to clarify, Sophie, the reason that planning is suggesting the 2-year limit is so that the applicant can do a rezoning application.
Yeah, I'm aware of that, and so I want to know what duration you think would be reasonable, if not 2 years. Because I believe you said that you would be looking at rezoning, like you're planning to.
No, I think she doesn't want to go.
Oh, you don't want.
She wants the approval today.
Okay.
Yeah. If there's no more questions, we're going to take this into committee then. I'm assuming there are no more questions. Okay.
Chair, I'd like to make some comments first.
Please.
I don't think there's any doubt whatsoever that this is paramount use in the community, in the neighborhood, and in the area, as a matter of fact, right across Etobicoke. It is a desirable use, and the tests speak about being desirable. I think the problem that we're having with, as a panel here, is that we're being asked to change the land use. And frankly, in my view, as a member of the Committee of Adjustment, I don't think we should be changing the land use. We should be giving variances or small changes to the performance standards to something that's already zoned. And as I've said this morning, and maybe you were here, I do trust the professionals at city planning. They're professional planners who take the time to ensure that the intended purpose of the official plan and zoning bylaw are adhered to. We have an official plan that designates use. We have a zoning bylaw that implements that official plan, the performance standards that have to go in. And my difficulty with this application is not so much the use and what's there. The use is amazing. I've known the area, it'll really age me a lot, but 45 or 50 years. I know Royal York Road from the beginning of reconstructing to adding the bicycle lanes. It's got amazing access to public transportation. You've got a bus, a transit stop in front of you. There is some additional parking on the side streets when there is some overflow. Driving habits are changing. All the good stuff and the services you're providing are amazing. And I'm not just saying you as a doctor, professional, and the rest, because you have everything else in there. It's almost a complete, I come there and I can have my hearing checked, I can have my eyes checked, I can have my therapy done, I can do everything there. Wonderful facility. But the problem I'm having, if you have a planner on your team, is interpreting this as asking the Committee of Adjustment to change a land use. And we should be looking at variances. And I'll only take one other minute. The reason I was asking you about that first comment, because it does take a long time to get a rezoning. But if you had, and I think 2 years is not enough, certainly, because in terms of returns, monetary to returns, because you're providing a service there, you still have to make some investments. I was thinking more like 4 or 5 years, and in 4 or 5 years, those things could change. You could still operate, but in tandem, should you be looking for rezoning? So I'm not sure if you have someone in your team that might be able to speak to the land use aspect. That's my only concern.
And my only concern is 4 or 5 years and I lose half of the team.
Well, we've actually technically gone into committee, so I actually should ask Deputant to to have a seat, please. And that's why I was asking, do we have any more questions? But I think Mr. Gully, what you're saying is that this is probably beyond the scope of our committee to de facto do a rezoning, because that's what this application is asking.
Sure, in my view, I think it is a change in land use, and I don't think we have the authority to do that. Not sure if the manager, secretary, treasurer could comment on that. Or again, if the applicant has somebody in their team who might be able to speak to that.
I know, but at this point, they've already given their
presentation.
So they have an application before the committee for a use variance. They are permitted to ask for use variances. It's up to the committee whether you want to grant it, refuse it, or grant it on a conditional basis. But you do have the authority to grant use variances if you feel the application is appropriate.
I think the other point that was made is that this use essentially has been in place for some time now anyway, but it's not an application, like really you would think this would be an application to legalize and maintain, but it's coming before us as to grant permission for. I think that's part of the confusion. Because there was no order to comply or anything like that, so. So it's kind of like, you know, the applications that are after the fact, where we can't consider the fact that it's been built as part of our deliberation. We just need to consider it on the merits.
So, Chair, on merit, I'm prepared to make a motion.
Go ahead.
Chair, in my view, the use is in the surrounding community is residential, but the existing building and the existing use is on a major road, Royal York Road. It's a major road with public transportation that provides people attending the facility with direct access to the Blue Ridge Danforth subway and points further on. The site has amazing transportation services, both in terms of road and in terms of transit, bicycle, pedestrian. It also has an area captive audience, captive residents in that same area. My issue was particularly with respect to changing the use. And given the conversation that's gone on here today, I feel very comfortable, particularly because of the use that's there, the use that will continue to grow and provide the services that this community, this neighborhood, and Etobicoke requires. I'm going to move that the application be approved with conditions 2 and condition 3.
excluding condition 1.
I'll second that.
Sorry, there's also transportation conditions of approval. Or requested anyway.
Does have conditions. Thank you, Chair. The October 13th, they support, but there are conditions. I'm not sure if it's a condition regarding driveway design or access, but there are conditions with respect to transportation. Yes, I'll accept that.
I'll second the revised motion.
Okay, all in favor? Okay, we have
Sorry,
approval.
who moved that? I didn't.
Was moved-
Seconded. Sophia?
Sophia seconded. I just want to point out that the city planning department does have the right to appeal, so it may not be over yet. Thank you. Okay, item 16. 13. I'm wishing. Yeah. Well, no, it's I'm looking at the wrong number. It's 16. Item 13 is 16 Pritchard Avenue. And it is a application to construct a new front porch and a new detached garage in the rear yard. And there are 2 variances being requested. And Bruno Lopez is the agent, and I believe he's online.
Yes, Mr. Chair, they are present, and I have unmuted them.
Thank you. Mr. Lopez?
Good afternoon, Mr. Chair and committee members. My name is Bruno Lopez. I'm Excel Engineering and Associates located at 1649 St. Clair Avenue West. I'm the agent on behalf of the owner.
Thank you, Mr. Lopez. I don't think we need a fulsome presentation here. If you want to just touch on some points, and then if the members have any questions.
Yes, this is as very straightforward as it can be. It's just a rebuild of the front porch, which is aging, and a brand new garage at the back. Like everybody has a garage at the back. Very simple.
Okay. Any questions, panel members? And is anyone ready for a motion?
Happy to move that we accept this application. It's certainly minor in nature and consistent with the 4 test. And there are no conditions or concerns noted by any of the departments.
Seconder? Mr.
I'll
Taylor?
second that motion, Mr. Chair.
All in favor? Unanimous approval. Thank you, sir.
Thank you.
I'm assuming we can push through without a break this afternoon. Is everyone okay? Yeah, okay. So item 14 has been deferred. So we are on to item 15, which is item 15 is 9 Allenby Avenue. It is a application to legalize and maintain the existing shed in the rear yard. And this was deferred from September the 28th. Planning has a condition of approval, and that's all we have.
While I have this moment, Mr. Chair, I'll bring to your attention that the area resident is present on the call.
Okay. And the agent is Dennis Sitik.
Dennis, you're unmuted. Go ahead.
Great. Thank you very much. Good afternoon, Mr. Chairman and committee. My name is Dennis of Dennis Sitik Architect, located at 15 Windermere Avenue in Toronto. I am the agent for the owner of 9 Allenby Avenue. Application is to legalize and maintain the existing shed in the rear and subsequently address the order to comply, which was issued to this rear shed. Application seeks relief from 3 variances: lot coverage of 10.1%, maximum permitted floor area for all ancillary structures of 70.2 square meters, and the requirement of the 50% soft landscaping. The as-built condition for soft landscaping is 28.6%. And we are aware of a staff report for the installation of permeable paving, where there currently is 3 extra parking spaces on asphalt paved parking pad. The shed has supported the property since approximately 2009, and understanding that it does exceed the ancillary structure floor area. It also does support just maintenance equipment for the property, inclusive of garbage and recycling bins, maintaining a cleaner property at the back and not having random bids throughout the property. So those are our requests from the variances, and the owner is aware of the staff report, and they have agreed to staff report's condition for permeable paving.
Okay, thank you. Any questions from the panel? No? Okay, thank you. Is Brenda Moody on the phone? Or
Yes,
online?
Mr. Chair, I'll go ahead and unmute them right now. Brenda, you're unmuted.
Welcome.
I'm observing only this afternoon. Thank you.
Okay, thank you very much. In that case, given there are no questions, we'll take it into committee, and if anyone has any comments or if they're ready for a motion.
Members, we need a motion.
Chair, prepared to move a motion on this. I just want clarification with respect to urban forestry. Was there a requirement under 1 and 3?
That's for item 16.
Next item.
115.
Yeah.
Yeah, there's no forestry.
Okay. For some reason, I have 1 and 3 for item 15.
That's for item.
Chair, I'm prepared to move approval and authorization of these variances subject to the planning condition regarding the rear yard spaces.
Permeable pavers.
Yep.
Okay, is there a seconder?
Sure, I'll second it.
Thank you. All in favor? Okay, approved. Item 16, 88 WANISKA Avenue, and this was deferred from August the 31st. Let me just pull it up to see what it is. Okay, so this is a application to construct a new detached dwelling with an attached garage. There are a total of 9 variances being requested. Forestry is requesting conditions 1 and 3. And I think that's all we have. And the agent is Dale. Is there agent on the line?
Good afternoon.
Good afternoon, sir. Can you please give us your name and address?
Dale, your full name and address, please.
Yeah, it's Dale Terrio of Trenton Drafting and Design at 32 Holland Street, Trenton. Yeah, it's Dale Terrio. Can you hear me? Sorry about that. It's Dale Terrio of Trenton Drafting and Design, 32 Holland Street in Trenton, Ontario. I'm the agent for the property owners.
Okay. Okay, I don't know if we need a full presentation, but I have questions, or perhaps you could do just a quick summary of what you're proposing and sort of why we wound up getting deferred.
Absolutely. So we were deferred at the request of planning. They thought our variances originally were a little high. The main reason why our gross floor area was high was because the basement was being counted as gross floor area. So what I've done in working first floor
Fading
down,
in and out.
pushing the basement down. Oh, sorry. Can you hear me?
Yeah.
I must be a bad connection. We work with planning to bring down our minor variances, particularly the gross floor area. We pulled the ground floor down and left part of it up above the garage. So what that did was made the first floor our first floor and the basement. So the basement would not be counted as gross floor area. That was the big change that we did. I also lowered the dwelling by about a foot.
Okay. Are you retaining part of the existing structure?
That's correct. There's the wall on the part of the wall of the front of the house and part of the wall of the side of the house. That's why we're asking for the minor variance.
Is that why you have the variances on the side yard setbacks? Okay.
That's correct, yes.
Thank you. Does anyone else have any questions? If not, is there anyone else on the line, or that's it?
Mr. Chair, yeah, nobody else is on there virtually.
Perfect. And I don't see anyone in the room, so we can take it into committee for discussion and or motions. Members, any comments? Or is someone ready for a motion?
I'm happy to make a motion. So I acknowledge that the applicant's taken the time to work with planning to address the concerns, and I find that the application before us is minor in nature and meets the 4 tests, and I would recommend approval subject to forestry conditions number 1 and 3, and I believe that's the only conditions that there occur. Thank you.
Seconder?
I'll second that motion, Mr. Chair.
Okay, Mr. Taylor, all in favor? You have unanimous approval. Thank you. And that being our last item, is there a motion to adjourn? Thank you, Mr. Taylor. All in favor?
Second it.
All in
Thank you,
favor?
members.
We are adjourned. Thank you. Thank you, staff.
Thank you for your first great hearing.
Hopefully shorter too.